Senate Bill 503, Senate Resolution 793, 954, and 955.
Thank you, Mr. Chairman. If you don't mind, Mr. Chairman, I've got Mike Mears with me that can help out, especially on all of the resolutions.
I'm happy to have
to
you.
the committee. This is Mike Mears, who is Executive Director of the Indigent Defense, or the Public Defenders Standards Council. He is the Executive Director. If you don't mind, Mr. Chairman, letting him explain, which one would you like to take up first?
Why don't you start with 503, and then,
Okay.
then we can go into the resolutions.
All right, sir.
Mr. Chairman, as you said, I've been before the subcommittee already this morning on this bill. Very briefly, this is a bill that fills in some of the gaps that were in the original Indigent Defense Act of 2003. It has basically some cleanup provisions to change, like for instance, changes multi-county public defender to capital defender, some changes like that. Probably the most substantive part of 503 is the establishment of the indigency standard, the mechanism by which an individual is determined to qualify for a public defender. As you recall, the council has previously established by resolution the mechanisms by which people are qualified or unqualified for the public defender services, and it's put into this bill to basically give it statutory authority and to make sure that it lasts beyond any one council. The section dealing with the indigency standard provides that if an individual's family income is less than 125% of the national poverty guidelines, then that individual would qualify for the services of a public defender in a misdemeanor case. If an individual makes less, or family income is less than 150% of the national poverty guidelines, he would qualify for services on a felony. And then the same provisions apply to the juvenile, and the juvenile would use the parent's income to determine whether or not an individual is qualified. That is a part of this, and my understanding that members of the legislature and the governor's office wanted to put this into this particular legislation so that there wouldn't be any question that it was recognized as a statutory matter as to who qualified for the services of a public defender. The other matters that set forth in here deal with the collection of the $50 application fee. Indigent Defense Act of 2003 and House Bill 1EX provides that an individual, if they ask for the services of a public defender, they're required to pay a $50 application fee or an administration fee. The question has come up as to whether or not that should be tacked on to the end of a case if an individual is not able to pay the $50 application fee up front. Some of the judges asked that we had asked them to use the probation process of using the collect. It's quite difficult sometimes to get $50 from someone who's applying for a public defender and they're sitting in jail without any money. So rather than delay the processing their case, it's sometimes better to collect that fee at the end of the case rather than up front. The provisions of 503 gives the judge the authority to tack that application fee on as part of the probation, the part of the probated sentence. We feel that that will help us collect more of the application fee that's currently been collected. And I would be ready to answer any questions, Mr. Chairman, about 503. We feel that it's necessary to clean up the original Indigent Defense Act, make some of those changes that need to be made. It also has a substantive provision in to change the method by which the $50 application fee can be collected, also the establishment of the Indigent Defense Act. There's also a provision in here, there's been some question raised by law enforcement as to whether or not the public defender investigators' use of an identifying badge was confusing to people at the jail, and this simply clarifies that and says that public defenders' badge has to be distinctive, and we certainly have no problem with that. We want to make sure that the sheriff's are part of the solution to getting into the jail, and we don't want to create any impediments to that.
Everybody has a badge now.
Yes, sir.
A couple of things briefly. One, this bill would codify the eligibility standard for indigent legal services.
That's correct.
And secondly, there was some discussion earlier this session about who it would more appropriately lie to make that determination. So we're still leaving it with the public defender's office, but there really is going to be no discretion now under this standard. Is that a fair
Yes.
characterization?
Mr. Chairman,
Sure.
could I address that? If you look on page 7, on line 15, it says, providing it shall, that the indigent defense services shall determine the financial. Now, I do have a question. I had to leave this morning, come back over here to the other Judiciary Committee about a bill, and was not there for all of the testimony in the subcommittee. I do have a concern on page 3, section B, where it specifies who qualifies, and then it says, unless there's evidence of the 150% of the federal poverty guidelines, unless there's evidence that the person has other resources that might reasonably be used to employ a lawyer without undue hardship. However, then on line 11, it says, in no case shall a person whose maximum income level exceeds 150% of the poverty level be entitled. My question is, are those two in conflict when you read them?
I don't believe so, Mr. Chairman.
Okay.
Mr. Crawford. The reason I don't is because there are some instances where a person may have some real property. It's not income. And I think that in those instances, if a person has income, has property that can be disposed to obtain funds to hire an attorney, then I think this provision gives them that opportunity to dispose of that income, so that you don't have someone who has land or something like that that could be encumbered.
I understand, and I think that it was, I came by to see you before the meeting started. I hate to do it here, but it also says in no case, even though there's an undue hardship, in the second paragraph it says in no case. Here's my question though, Mr. Chairman, is who's going to make that determination?
It's our understanding that determination would be made by the circuit public defender or the entity that's providing the services. In some opt-out counties, there's an indigent defense administrator or coordinator who will be making that determination where we don't have a public defender office. But this legislation, I would respectfully submit, leaves that responsibility with the circuit public defender, and I most respectfully request that it remain the responsibility of the circuit public defender, because that person is accountable to the council, is responsible to the legislative oversight committee, and that way there's no question. The discretion, as you indicated, has been taken out. So if an individual's income is 150% or more than 150% of the national poverty guidelines, they're not going to be able to receive indigent services. They'll have to pay for their lawyers.
And I'm sure you will communicate to your public defenders that the hardship needs to be narrowly interpreted, because the scenario raised by Representative Crawford, I think, is one that the legislature would not be happy with, and that's to see folks that wouldn't go borrow money against land or liquidate and then have the taxpayers pick up the bill for their legal defense.
Mr. Chairman, we received that message loud and clear through the Legislative Oversight Committee, of which you are familiar, and I can give you my assurances as the Director of the Council. We heard the message. We understand the message. As I say in the Navy, we'll carry out that message.
Questions for the author or Mr. Mears from the committee? Questions from the committee?
I have a motion that's appropriate.
This is an example of good subcommittee work right here. Recognize Vice Chairman Mumford.
I move do pass on the committee substitute the SB 503.
We have a motion that Senate Bill 503 be given a do pass recommendation by committee sub. Is there discussion on the motion? Is there discussion? Hearing none, the chair calls the question. All in favor of the motion, please indicate by raising your right hand. All opposed?
Thank you, committee.
You want to go into the resolutions now?
Yeah, if that's what you wish to do.
You're on deck, Senator Douglas.
Okay. Mr. Chairman, with regard to Senate resolutions, these are resolutions that will give approval to the standards that have been adopted by the council. As you and other members of this committee know, the Legislative Oversight Committee was created by the legislature to determine whether or not any of the standards that the Standards Council passes have a fiscal impact. And if they have a fiscal impact, then those standards have to be ratified through a resolution of both the Senate and the House and signed by the governor. At one of its first meetings of the Legislative Oversight Committee to look at the standards that have been adopted by the council, the Legislative Oversight Committee, in its wisdom, determined that all of the standards have fiscal impact. So we bring these to you. The first one is the standard for removal for cause of a circuit public defender. The legislation creating the statewide public defender system provides that circuit public defenders are appointed by a local nominating committee of individuals who live within the circuit where that circuit defender is going to serve. However, the legislation puts the responsibility for removing a circuit defender on the council itself. The council, pursuant to the statute, is given the responsibility of coming up with a standard for removal, outlining what are the circumstances and how by which a circuit defender can be removed, and what are the basis for removal. That's what the Senate Resolution 793 is. As I indicated to the subcommittee this morning, we have followed the merit system as best we can, merit system procedures for removal. It's basically due process. If there's been an allegation made that a circuit public defender has violated one of the standards by which they can be removed, the director presents that information to the council. The council then finds probable cause. That initiates the removal procedure, and the circuit defender is then notified in writing of the reasons for the requested removal. He or she is given an opportunity to respond, have a hearing, prepare a defense, and bring in witnesses. And only after all of those procedures have been followed could a circuit defender be removed. We feel that this is absolutely necessary for the administration of the circuit defender system. There has to be an accountability, and the legislature has given that responsibility for maintaining accountability to the Standards Council. This gives us the tool to remove a circuit public defender if he or she warrants removal. Without this, it would be extremely difficult for us to initiate it.
It's a guideline at this point until it's adopted.
Right.
Questions from the committee? Questions from the committee? It's a pleasure of the committee.
Second.
We have a motion, and I'm getting confused. Was this 793?
This is 793, Mr. Chairman.
We have a motion that we give a due pass recommendation to Senate Resolution 793. Is there discussion on the motion? Is there discussion? Hearing none, the chair calls the question. All in favor of the motion, please indicate by raising your right hand. All opposed?
Thank you, Mr. Chairman.
Senate Resolution 954.
Mr. Chairman, if I can, this is a standard which the council has adopted and submitted to the Legislative Oversight Committee, which provides for a set of performance standards by which public defenders are guided in their representation of individuals in their care. There's nothing revolutionary in these standards. It simply puts in writing what most good criminal defense lawyers are expected to do automatically. But in case there was ever any question about what's expected of our public defenders, this standard clears the air and says, for instance, you will interview all witnesses, you will look at immigration consequences of a plea of guilty. It basically walks a public defender through the process of defending an individual. And I think for the first time, it will give the legislature and the council working together an opportunity to say in writing what's expected of a public defender. I think that this is going to not only help the individual circuit defenders where they need some guidance, it's also going to establish a standard by which their conduct is governed. And as long as they are following these standards, as hopefully you will approve, then I think it's going to go a long way in reducing the number of ineffective assistance of counsel claims that are upheld by the court. We're always going to have those claims, but I think that if the individual follows these guidelines in providing the indigent defense services, it's going to go a long way in preventing cases from getting reversed for ineffective assistance of counsel.
Questions from the committee? Representative Abdul Salam.
Thank you, Mr. Chairman. Thank you, gentlemen, for being with us again today. One of the questions that I did not ask this morning was you pretty clearly defined how your committees are appointed and how the Standards Council is staffed and what the staggering of terms will be. How is the Legislative Oversight Committee formed, and who appoints those people, and how many is on it? And I mean, I don't see anything about the Legislative Oversight Committee.
The Legislative Oversight Committee is appointed by the legislature itself. The Senate and House has equal members, and the chairmanship of that is rotated. Last year, Senator Hambrick was the chair. Representative Crawford is the chair this year. The Legislative Oversight Committee basically is another layer, if you will, representative, of oversight over how we spend the money that's appropriated by the legislature. It's primarily a fiscal, and probably should say it's a fiscal watchdog over the public defender system to make sure that the money that is allocated to us to provide representation is properly spent, and also that we don't initiate rules and regulations that would increase the cost beyond what is reasonable in providing our services.
How many people on it?
There are 10 members of the Legislative Oversight Committee.
Thank you.
And
Thank you.
Can I follow up on that there? 10 members. We're mandated to meet 6 times a year. Representative Ralston is on it. I'm on it. And if we do meet. We look at each one of these standards. We look at any of the fiscal impact. They provide us at each meeting with basically a financial sheet of where they are, how much they have spent. We also review the number of cases that they have open, the number of felony cases, misdemeanor cases by circuit, by counties. Also, one other thing is the death penalty cases. We monitor those, and the committee has had some interaction with the staff and with Mr. Mears, especially about some of the death penalty cases and the cost, and and Representative Knox is also, that's on this committee, is also served on there. And that was part of EX1 when Indigent Defense Council was set up.
Okay.
I think it's been good because we do sort of pre-clear what you're seeing here today in these standards.
Okay. Follow up, Mr. Chairman?
Sure.
Just while I've got it. Mr. Mears, this morning I asked you the difference between the requirements for immigration in the juvenile, which you'll get to in a minute, and in 954. Would you just please direct me to the language in 954, since we're looking at it, about the immigration requirements?
You'll find it in a couple of different areas, if you will. There's obligation to counsel under sentencing hearing, the performance standard 8-A, and 8-A. And I'm just going by the...
I'll find it, yeah.
And there is, throughout these provisions under these standards, it requires a defense attorney to make inquiries into any factors that would impact a person's immigration status. So that the problem we have quite frequently, sometimes the Immigration Service will not initiate the revocation of resident alien status because of certain offenses, they will for certain other offenses. What these standards require them to do, Representative, is to make a proper and reasonable investigation into those matters.
Would that be under D? No, that's not it.
At one time, I thought I had these memorized. I'll find it for you.
Thank you. I won't hold for that answer, Mr. Chairman. We discussed it earlier. Thank you.
Chairman Knox.
I just want to ask you, Mr. Mears, isn't it true that these standards have been changed since the original standards? We've went through a couple of versions of these to arrive at the standard we're currently talking about.
Right, and these have been published, and we've had quite a bit of, as I think the word is, that we've had quite a bit of vetting, not only by the Legislative Oversight Committee, but also other groups, to make sure that everyone knows that these are the best possible standards we can come up with.
Further questions from the committee? Further questions? What's the pleasure of the committee on Senate Resolution 954?
I move to pass.
Have a motion that Senate Resolution 954 be given a due pass recommendation. Is there discussion on the motion? Is there discussion? Hearing none. Chair calls the question. All in favor of the motion, please indicate by raising your right hand. Any opposition?
Thank you.
Senate Resolution 955.
Mr. Chairman, if I could simply repeat everything I said, not by reference what I said about the adult performance standards, and that applies to the juvenile performance standards. We recognize, as I'm sure members of this committee recognize, that juvenile cases present a special challenge for most criminal defense lawyers. The Indigent Defense Act of 2003 requires that every public defender office have a special office set up in the Circuit Defender's office for handling juvenile cases. It has to be a designated office. We recognize the specialty that's involved in representing juveniles, and one of the things that we have committed ourselves to as a Circuit Defender system is that we're not using juvenile proceedings as a training ground for the adult. What's happened in some cases, some instances in the past, a young lawyer will go to work at a public defender's office, and the natural inclination is, well, we'll put you down in the juvenile and let you get your feet wet and then move you up to the, quote, more important cases. Well, we feel that the juvenile cases are more important, and we want to make sure that the individuals who are in those courts, the juvenile courts, are there because it's a specialty. We recognize that, and we have additional Representative, you asked me this morning about the difference. These are additional standards. I wasn't quick on my feet to tell you that this morning. These actually indicate additional standards to those that we have, that you just approved. So we feel that the juvenile standards enhance our ability to require our attorneys to provide the service that the legislature expects them to provide.
Okay. Questions on Senate Resolution 955? Questions from the committee? We had one more speaker, Kim Kimbrough, with the... You didn't want to speak?
Well, having been called on, just to say that the Legislative Oversight Committee and the Public Defender Standards Council have been very open and upfront in involving the counties in this process, and we are one of those groups that Director Mears spoke of in terms of our support for these standards.
Okay, thank you.
Thank you, sir.
What's the pleasure of the committee with regard to Senate Resolution 955? We have a motion. We have a motion and a second. We have a motion that we give Senate Resolution 955 a due pass recommendation. Is there discussion on the motion? Is there discussion on the motion? Hearing none, the chair calls the question. All in favor of giving Senate Resolution 955 a due pass recommendation, please indicate by raising your right hand. All opposed?
Mr. Chairman,
Thank you very much.
Thank you very much.
Thank you, Mr. Mears, and to Representative Crawford.
Thank you, sir.
Well, the members of the committee, it took us 20 minutes to do 4 out of 9. We're almost halfway there.
I'm trying to help you.
Good subcommittee work this morning.
Might as well laugh.
I know.
Senator Douglas, Senate Bill 64.
Thank you, Mr. Chairman.
Hold on just a moment.
All right. We're getting our act together here, too.
If someone would be kind enough to close the door. Okay, let's have some order. Senator Douglas, Senate Bill 64.
Thank you, Mr. Chairman. It's a pleasure to be back with your committee this afternoon. Ladies and gentlemen of the committee, I bring to you Senate Bill 64. This is a bill that's 2 years old, has been completely reworked since it was first brought out in the Senate last year and sent back to Senate committee for fine-tuning, and I think what we have today is a far better bill that satisfies many of the concerns that were expressed in the Senate at that time and some in the House as well. This is a bill that will address the safety concerns of many on this committee and many in the House and the Senate. It will at the same time provide to the law enforcement agencies of Georgia their number one legislative priority. For the first time, Georgia law would allow for a person to drive to a safe spot if they feel they're being stopped in an unsafe location or manner. This has been a particular concern to those of us with young daughters and wives who drive sometimes at night or are preparing to drive, like my 14-year-old daughter who will be 15 in 2 weeks and has already informed me that we'll get a learner's license 2 weeks from probably today. Thank you.
Happiest days of your life are about to begin.
Yes. Previously, there has been no legal safety mechanism that allowed in Georgia law that allowed for such a thing as driving to a safe spot before being stopped by law enforcement. SB 64 says that a person who is being stopped in a location that may be unsafe may respond by slowing down to 50 miles an hour or less, depending on the speed limit, turn on their flashers, and proceed to a safe spot to stop. That could be a lighted area, parking lot, or whatever happens to come along that will be a good stopping place for the driver and the officer. Now, for law enforcement, the bill would allow for optional light bars on top of their vehicles, which are routinely involved in traffic enforcement. Only since 2001 has Georgia law required such light bars. You got one of those pictures that show a light bar. Show what we're talking about. Okay. The light bar is a bar of lights that goes across the rooftop of the car. Most law enforcement officials will tell you that light bars are like neon signs telling motorists to obey the law while within sight of a police car and then resume their illegal activities once the coast is clear. How many times have we been away from a police car on the highway and seen something that made us wish that a policeman was present? It happens most every day, especially when you drive the interstates. With SB 64, those breaking the law will not know a police car is present until they're so close that the officer will have seen their activity also. But there is a caveat. There would be no removing the light bars without two important conditions being met. First, the car must have what is called a new device that is called an illuminated agency identifier attached to the front windshield. You can see here it says State Patrol underneath the, okay, so that you can read that through your rear view mirror where it says State Patrol on the front of the police car there. It will say State.
Better than mine.
If they're behind you, you'll be able to read it. As you can.
Usually you're not reading, but
as you can see from the photos here, the IAI representative is clearly recognizable from the rearview mirror of the car being stopped and from standing outside of the automobiles. This IAI would also say Sheriff's Department or Police Department, depending on the agency that's doing the patrolling. The second item that must be accomplished to qualify the car for slick top status would be to have the blue lights located on the front, back, and in the passenger compartment conform to Georgia State Patrol standards as already are written in the Georgia law. That would prevent a law enforcement agency from just putting up one or two blue lights somewhere on the vehicle and putting it on the road in what, for all practical purposes, would be an unmarked vehicle. Georgia law will also continue to require that police vehicles be marked so as to be easily recognizable, again precluding unmarked vehicles from routine traffic enforcement. The bottom line with SB 64 is that we have a bill here that will enhance the safety of drivers on our roads, while at the same time giving law enforcement the tool they're asking for to better serve the law-abiding public using the roads of Georgia. I want to thank Colonel Hitchens, our Public Safety Director, and his staff, and particularly Sergeant Mark McDonough here on my left, for their help on this bill. I also want to thank all the members of the House subcommittee who heard this bill earlier under Representative Mumford for their attention and support of the bill. So, Mr. Chairman and members of the committee, I'd ask for a favorable consideration of SB 64.
Questions from the committee? Chairman Bordeaux.
Thank you, Mr. Chairman. First of all, I agree with everything you're trying to do here. Have a question about some of the language.
That makes life a lot easier when you do that.
Well, let's hope so.
Okay.
First of all, at the bottom of page 1, line 27, you use the term under normal atmospheric conditions. Do you know if that's used anywhere else? I mean, it's
That's written into Georgia law. That's what it says. Obviously, we can't put an aircraft searchlight on a car that we cut through fog for a mile ahead down the road. So it just says normal atmospheric conditions.
Do other code sections use that? I just don't know.
Is that already, that's already in Georgia law?
Do you know where?
It's in the same code section that addresses the standards for the blue lights that the State Patrol has now. And I don't have the.
Okay.
I'm sorry. 40-8-91.
All right.
Under the Georgia Code.
Thank you. And on the second page where it talks about an illuminating agency identifier.
Yes, sir.
You all may know what that means, but
that's what we showed you.
I know. Now that I see it, I know what it is. But
well, it's a new device. That's why there was some question in the Senate about turning these into unmarked cars. Okay, without the light bar. And so this is a direct response to several senators who were concerned that you could get pulled over and not know who was behind you. And so it will say, if there's no light bar on top of the car, it's going to have to say State Patrol, Police Department, or Sheriff's Department on that identifier.
The only suggestion would be that we might want to say, rather than use this, what I don't know whether you want to call it a term of art,
IAI is what I call it.
All right, IAI. Rather than saying an IAI, why not say that that it's got to have a lighted.
Well, that's the name of it. Illuminated Agency Identifier. That's what the name of it is.
Well, I guess then the question I would have is, what if you want to use some other way of lighting your name? I mean, you're restricting yourself to this particular product, I guess.
I don't know that there are any other devices out there that do that.
Well, there may be 2 years from now.
Well,
I mean, why not just say, which also has lights identifying the agency reasonably visible, rather than limiting yourself to that particular device?
Lights identifying the agency and illuminated agency identifier. Almost, to me, and I'm not trying to be smart or anything, President Bordeaux, I'm just saying, to me, the verbiage, you're getting into semantics. We're talking about the same thing. We're just talking about two different ways of calling it.
Okay. Then lastly, with regard to Section 2, again, I think that's commendable. What I'd like to see this language provide, though, is if I'm stopped by a police officer and I'm on I-75 and there's no place for me to pull over, I would normally turn on my right turn signal to indicate that I'm trying to slow down, I'm pulling off to the side of the road, but I wouldn't think to put on my hazard lights. This bill requires the hazard lights.
I think that if the officer sees you turn on your hazards or your right blinker and making a legitimate effort to pull over in a safe spot, I think, we can't legislate common sense, Representative Bordeaux, so I hope there'd be some out there on the highway.
Well, you're right, we can't legislate common sense, obviously, but we can try to write common sense into the statute. And all I'm suggesting is, would you have any problem with adding on line 13, page 2, where it says the vehicle's flashing lights, simply add the vehicle's flashing lights or turn signal? Because, I mean, I don't know about the rest of the committee, but I wouldn't turn on my flashers, I'd turn on my turn signal.
And,
I'll recognize you. Do you want to respond to the question?
well, I don't know that there is a response, Mr. Chairman.
Okay.
I think that for the moment, I'd prefer to stay with what we have.
Is there any way it does harm to the bill to make it a turn signal? I mean, yeah.
No, it doesn't harm the bill. I'm just saying that, we've gotten this far with it. I just prefer to stay with what we have at the moment, since I think we're talking about semantics here, and we're talking about the same thing. We're just approaching it from different directions.
Well, flashing lights and turn signals aren't the same thing, and if we want to come on, I'm just trying to write the bill the best way we can. That's our responsibility for this committee.
I understand.
Then lastly, lines 14 and 15, where you talk about got to observe the posted speed limit, but in no event shall exceed 50 miles an hour. Obviously, suddenly slowing to 50 miles an hour on I-75 could be hazardous.
At the same time, staying at 80 is not going to indicate to the officer that you're trying to stop.
Right, and I would suggest that we change the language to be that the motorist shall operate his or her vehicle at a speed and in a manner consistent with an intent to comply with the directives of the law enforcement officer.
Representative Bordeaux, I appreciate your suggestions, but I think that the bill is written in such a way that it would be safe for people to slow down to 50 miles an hour as they're being attempted, as the attempt to stop is being made, and proceeding to a safe location.
Thank you.
Representative Bearden.
Just to address a couple of the concerns Representative Bordeaux has. On page 2, line 13, displaying the vehicle's lights, it does not state emergency lights. Turn signal is a flashing light, and that turn signal could go to the right or left depending on where the safest part of the road is to pull over. Is that not correct?
That is correct.
And also, the 50 miles an hour, if you are on the interstate, that would provide you a safe speed to start slowing down from 80 or above, which they clock you at. And it would also, you still have the blue lights behind you, so it would be a safe manner until you found a safe place to pull over. Is that not correct?
Well, I don't think the bill expects you to slam on the brake from 80 to 50 in 2 seconds.
Correct.
I expect that you would be able to use a reasonable amount of braking action to slow down to 50 as you pulled over towards your safe spot.
Thank you, sir.
Further questions from members of the committee? Chairman Knox.
I guess this is more to Sergeant than it is to Colonel, but whenever you're pulling somebody over, I see this all the time. People being pulled over on the side of the road on 85 or 75, and we even passed a law last year to make sure that everybody goes over into the next lane to get around them. I think this is a good thing. I think that's where people ought to go anyhow for this kind of stuff, into a lighted area. It's safer for you and safer for them. So I'm trying to figure out how this works in practical. How would this work, practically speaking? How is it?
Representative Knox, when we train for our vehicle stops, this is something that has always been put out to our mothers and our daughters and our aunts to do this, and we're sensitive to that. And what we do is we look for that indication. We usually have a pretty good idea when somebody's running or when they're not, or they're up to no good. And we are patient, and we look for that spot. Whether it's 2 miles down the road or 3 miles down the road, we're very sensitive to looking this and train for this in our vehicle stops training.
You give anybody any indication they ought to keep going and get off someplace where it's lighted, on the expressway or the road or wherever you are when you're traveling? This isn't going to be practical all the time. If you're out in the boonies someplace, you're not going to drive 8 miles to find a lighted place, I don't guess.
I live in the boonies, and usually what happens is I'll pull up next to the car and roll my window down, and if I want them to yield, then I'll use a hand signal or a flashlight signal, or I'll indicate for them to keep going. I'll give an okay sign that I understand what they're doing.
I have found from experience that cars are equipped with loudspeakers where they can tell you to pull off.
Use our PA system as well.
PA system to tell you. I don't want to tell on myself, but in social circle,
I think it's too late.
In social circle the other night, I stopped at a red light, and he told me to use his PA to tell me to pull over off the side of the road. And then he just passed the time of night with me. I'll leave it at that. But they do have a PA system that they use for those instances like you're talking about.
Further questions? Further questions from the committee? Representative Abdul Salam.
As a fellow Booney Knight, I'm just concerned about what the protocol would be when you're in heavy traffic, and as we see all too often, citizens don't yield to the blue lights and the yellow flashing lights, and you've got this car that you're trying to get to move over. My car, when you've got the emergency flashers on, the signal doesn't work, so I can't indicate which way I'm trying to move over to oncoming traffic. What would we do to address that problem?
Ma'am, what we do is in heavy traffic, we clear that lane for you. We try to move over to get that cleared lane for you so that you can move over from the. That's also something that we practice in our vehicle stopping training.
Okay.
We try to do that for you. We try to help you get over there.
Yeah, it's just terrifying when you see people zooming faster than you guys.
Questions from the committee? Further questions from the committee? Recognize Vice Chairman Mumford.
I'd like to move to pass SB 64. I think that's not by substitute.
It's not.
It's not.
We have a motion that Senate Bill 64 be given a due pass recommendation. Is there discussion on the motion? Chairman Bordeaux.
Would now be the appropriate time to propose some
It
amendments?
would.
Thank you, sir. On page 2, line 13, I'd like us to add that language about, or the turn signal. It would be added after flashing lights. It would simply add the language or turn signal so that it would be to proceed to a safe location by displaying the vehicle's flashing lights or turn signal. And the purpose of the amendment, sir, would be simply to me, common sense would, if I'm pulled over, would be to turn on the turn signal to indicate that I'm about to pull off, and I'm about to pull off at the next street or exit, and not turn on the flashing lights. I'm trying to bring the law within what at least I think would be common sense. I don't see how it harms the bill in any way.
Mr. Chairman, I'll go with the pleasure of the committee on that.
Okay. Well, let me ask then, is in light of that, is there objection? Is that
objective? I believe it's stated perfectly clear in the law as it is right now on the bill, so I would object to it.
okay? Is there a motion to the, or I'm sorry, a second to the Bordeaux amendment? I should have asked for that earlier. Thank you. We have a motion that the Bordeaux amendment be adopted, and we have an objection by Representative Bearden. Is there discussion on the motion? The motion is to adopt the Bordeaux amendment. Representative Mangum?
Mr. Chairman, I would be in violation of the law right now, and I think I try to abide with all the laws. If an officer is pulling up in the back of me, the first thing I'm going to think about is turning my turn signal over to at least turn over. There will be no reasonable way to tell the officer that I'm trying to turn over. I wouldn't think about initially putting my flasher signals on. The first thing I'm going to do is do my signal lights. And there may be some other persons who would think to turn the emergency flashes on before you turn your signal lights on. But my good senator, I would ask if you don't strongly oppose this. Am I incorrect? Is that? I'm just.
I'll take the pleasure of the committee.
Yeah, but and I, with all due respect to my good colleague, Mr. Bearden, if you have some other reasoning other than I'm not aware of, because I was unfortunately predisposed in another committee and couldn't get here as quickly on this particular bill, but I would just think the common citizen, and we want to think about the common citizen, first thing they're going to think about is turning their turn signal on, not putting on emergency flashes, and then we may have an officer that is upset with them because they didn't comply with the law that they didn't even know about. Thank you.
Further discussion on the motion? Further discussion on the motion?
Mr. Chairman,
right,
if I may.
Representative Abdul Salam.
Just to reiterate again, if you've got your emergency flashers on, you can't turn your signal on. I mean, you can't indicate whether you're going right or left. That could be create a hazard.
You don't do both.
I'm arguing for the motion. Because in my hoopty, you can't turn a signal on with your emergency lights on.
It's an or.
What's known as a friendly question there, Chairman Bordeaux, I think.
I had some few, Mr. Chairman, I didn't recognize.
I understand. Chairman Franklin.
Mr. Chairman, isn't it true that there's nowhere in this section is the word emergency used as a modifier of flashing light? And isn't it further true that flashing lights could include emergency lights or turn signals? As turn signals flash, emergency lights flash.
Senator McDonough, you know the answer to that question?
It's put in there for the flexibility of this. And Representative, our colonel is going to do a public service to address these specific things in the law, to inform the public of what they will be able to do according to the law. And that's something that will be stressed of what they'll be allowed to do. What you're saying is very reasonable. The average person is going to put their right-hand turn signal on when they're trying to yield to the right. That's what the average person on the road is going to do.
Further discussion. We're about to call the question. Further discussion on the Bordeaux Amendment. Hearing none. All in favor of adopting the Bordeaux Amendment, which would add the words "or turn signal" after the word "lights" on line 13 of page 2, with a period after signal. All in favor of that motion, please indicate by raising your right hand. All opposed? Same indication. The Bordeaux Amendment has been adopted. Further discussion on the motion. Chairman Bordeaux.
Let me try one more, please, sir. On line 14, strike the
Page.
I'm sorry, page 2, line 14. Strike the language beginning with "observe," to post it to the end of the line there, to the end of the sentence there, and put in there this language so that it reads, "The motorist shall operate his or her vehicle at a speed and in a manner consistent with an intent to comply with the directives of the law enforcement officer."
Mr. Chairman, I'm concerned that becomes vague, a little more vague, and I would be opposed to that amendment.
Okay. Is there a second to the Bordeaux Amendment? Is there a second?
Second it.
We now have a motion. The author has indicated objection. Of course, you're not a member of the committee. Is there objection from the committee to the adoption of the second Bordeaux Amendment? All right. We have a motion and an objection to the Bordeaux Amendment number 2. Is there discussion on the motion? Hearing none, we'll call the question. All in favor? I'm sorry, Chairman Bordeaux.
Thank you, Mr. Chairman. All I was going to say, forgive me for slowing this down. The only thing I'm trying to do here is, rather than make it such a bright line test that the motorist has to slow down to 50 miles an hour or below, is to let them slow down. Let them slow down to whatever is the reasonably safe speed under the circumstances. It's got to be in compliance with the directives of the officer, though. I don't see how this harms the prosecution, the police officers at all. It simply, again, approaches common sense as to what should be allowed. The citizen has to operate his vehicle at a speed and in a manner consistent with his intent to stop.
Is there further discussion on the Bordeaux Amendment number 2? If not, we'll call the question. All in favor of adopting Bordeaux Amendment number 2 as stated, please indicate by raising your right hand. All opposed? One for two. That amendment fails. Further discussion on the motion. to give Senate Bill 64 a do-pass recommendation. Any further discussion? Hearing none, the chair will call the question. All in favor of giving Senate Bill 64 as amended a do-pass recommendation, please indicate by raising your right hand. All opposed? Thank you, Senator Douglas. Thank you, Sergeant McDonough. Always a pleasure having you with us.
Mr. Chairman,
Senator Doug.
606, Mr. Chairman.
Yes. While we have you here, we'll have Senator Goggins on deck. I know Senator Rogers was on the premises later. He told me his might take about 30 minutes, and so we'll finish 606 with Senator Douglas, and then follow that up with Senate Bill 396.
Mr. Chairman, I have some flyers for your committee members. So we'll point out why we're doing 606. Starting to feel important, Mr. Chairman.
I think they're actually getting ready for Senator Goggins.
Is that what it is?
You know. No, I'm teasing. If you'll do me a favor, would you call Senator Representative Burmeister down here for a moment so you and her and I can chat?
Yes, sir.
She's somewhere upstairs. I'm not sure where. Okay. Go ahead, Senator.
Thank you, Mr. Chairman. Ladies and gentlemen.
We're on Senate Bill 606.
SB 606. Thank you, Mr. Chairman. Ladies and gentlemen of the committee, today I have what I call the misfortune of having to bring to you SB 606, and I say misfortune because I wish that there was no need for such a bill, but in this sometimes brutal world that we live in, the need has arisen. SB 606, I'm sorry to say, has become necessary because of the actions of a very few who have traveled the country to disrupt funerals in many states, as you can see from the flyer that I printed off of their website this morning. Fred Phelps, a so-called reverend of the Westboro Baptist Church in Topeka, Kansas, and some of his family members and followers have demonstrated at funerals for slain soldiers, for Coretta Scott King, for West Virginia miners, and for AIDS victims. Simple demonstrations will not elicit the coverage and attention that these people have generated. These demonstrations are so vile and so repugnant that 15, and I understand the number now is up to 25 states, are currently working on bills to limit their activities or have passed the bills that were considered. Wisconsin, a bastion of liberal politics, and South Dakota, Missouri, and Kansas at the other end of the political spectrum have seen bills signed by their governors that will restrict this activity. When I say these demonstrations are vile and repugnant, let me give you some examples. These people demonstrated at the funeral of Coretta Scott King with signs saying that, and I'm going to use some inappropriate language in this committee room that would not be appropriate in the full House or Senate. They demonstrated at the funerals of Coretta Scott King with signs saying that she was in hell with her whoremongering husband. They were close enough to funeral attendees so as to be able to shout at some of the children accompanying their parents into the services in Lithonia and Atlanta. They've also targeted soldier funerals with signs such as, "Your son is in hell. We're glad your son is dead. America is a fag nation." They also picketed minor funerals in West Virginia and have worked their evil at the funeral of AIDS victims. In the past few days and weeks, we've honored in this capital Mrs. King, several members of the military who have been killed in action, and others. We've seen the grief expressed by their families and the unbearable pain that they have to endure. Now imagine that these same families would have to enter and exit a funeral location surrounded by signs that say, "God loves dead soldiers. Thank God for improvised explosive devices," or whatever. Imagine having to walk into the funeral of Mrs. King and have someone scream at your children that Mrs. King was some of the things that we said earlier. Imagine burying your minor father or son or husband and enduring the same indignity. I can't imagine that we all don't agree that these people are beneath contempt and are out of line with their actions. And so the question becomes what to do about it. I asked the Attorney General's office to assist Legislative Council in writing this bill. We looked at bills from Indiana, Kentucky, and South Dakota. Our bill, SB 606, originally was the least restrictive of all that we saw, the least imposing on the First Amendment rights of every American. However, the bill was amended in the Senate to put it more in line with the other states, and while it originally called for a buffer of 100 feet for keeping demonstrators back from funeral locations, processions, and cemeteries, the amended version that you have with you now has a 500-foot buffer, and on the advice of the Attorney General's office, we took the funeral procession out of the bill so that the bill that you have now only addresses the location of the funeral and the location of the burial. The key thing to remember here, ladies and gentlemen of the committee, is that we're not restricting the free speech of anyone. We're simply asking them to move back to give the family room to not have to endure the venom that these people spew. Now, to the surprise of no one, the ACLU followed me into this committee room the other day and into the Senate committee room when the bill was heard. Their representative spoke against the bill at that time. She said that the Phelps crowd has a right under our Constitution to do what they're doing. However, the ACLU has also said recently that our school children don't have the right to mention Christmas in school, and that we in Newton County did not have the right to use the word Christmas on our school calendar in 1999 and 2000. I find it difficult to understand why we don't have those rights in the opinion of the ACLU, and yet the Phelps crowd does have the right to do what they're doing. One of the things that I want to leave you with, Mr. Chairman, is a quote from a former Supreme Court Justice Jackson in 1949 in a Chicago case, free speech case. There was a 4-page decision written by Justice William O. Douglas throwing out a Chicago demonstration law, and Justice Jackson wrote a dissent, a 24-page dissent to a 4-page ruling. And Justice Jackson said basically that decisions of the court and decisions on the First Amendment have to be tempered with common sense, and that the Bill of Rights was not written to be an instrument of national suicide. What he was trying to say, Mr. Chairman, is that although the Bill of Rights is sacred in our society and in our country, we cannot take it to the extreme that we destroy ourselves with the provisions in the Bill of Rights, and that's close to what the Phelps crowd is doing here. So, Mr. Chairman, that's my presentation. I'll be happy to answer any questions.
Questions from the committee for the author. Chairman Bordeaux.
Mr. Chairman, could I add one thing before the question? Sure. That is, I just wanted to tell the committee that this bill passed the Senate 55-0. I'm sorry.
Thank you. I just need a clarification. Maybe I'm just not familiar with which bill are we operating from?
606.
I'm sorry, which LC number? Is it SB 606 FA2?
Let's see if I have the actual bill.
Is there another version?
This was amended. This is the first amended bill out of the. I don't have it in front of me, Mr. Chairman, but okay. This is LC SB 606 FA2.
Right. Diane, you're falling short today. As you originally introduced the bill, though, it had 100 feet.
It was 100 feet, and it included funeral processions. This bill that you have in front of you is 500 feet, and it deleted funeral processions. On the advice of the deletion was on the advice of the Attorney General's office.
Do you recall what the amendment did in terms of how was it drafted to delete the funeral processions?
The original bill said 500 feet of the original bill said within 100 feet of the ceremonial site, funeral procession or location. I'm on line 24.
Yes, sir.
ceremonial site, funeral procession, or location was the original bill on line 24. And this amended bill changed the distance to 500 feet and struck the funeral procession. So now we're just talking about the ceremonial site and the memorial service site.
Because it still refers to the I guess the processional refers to the demonstration.
No, the processional is used here, as I understand it, talks about the demonstrators.
Yes. And was it on the advice of the Attorney General that y'all had it at 100 feet rather than 500 feet, for example?
We originally were trying to walk a fine line on the First Amendment, that to write a bill that would not be thrown out of in court, but with almost all the other states using 500 feet, there was sentiment in the Senate to go to 500 feet.
Do you know if those other states' provision for 500 feet have been upheld?
None of them have gotten that far yet. These are all brand new bills across the country.
Because of this wacko group?
Right.
Okay. Would you feel more comfortable on legal constitutional grounds to restore it to 100 feet?
No, I'd prefer to stay at 500.
I mean, it's going to cost the state a lot of money to lose it.
Well, the amendment in the Senate for 500 feet passed unanimously.
Well, y'all sometimes hit 500 too. So.
Well, I would remind you, and it may be the case in the House also, but we have a senator who is now or was currently on the board of directors for the local ACLU, Senator Fort, and he voted for this bill.
Yeah. And I may be mistaken, but the representative, I was in here a little early today, and I saw the representative from the ACLU in here prior to you coming in, so I don't think she followed you in here today.
Okay, well, I'm sorry to hear that.
I think you followed her.
All right. Any other questions for the author? Seeing and hearing none. We had Ms. Garrett signed up to speak on this bill. Do you have a question?
Yes.
Go ahead.
What's the punishment for violating this?
It's a misdemeanor.
And if I could just ask another follow-up question. This conduct is abhorrent, but I don't understand why our existing laws aren't sufficient. We have disorderly conduct, terroristic threats, criminal trespass, simple assault. There's a variety of misdemeanor and felony offenses that we could charge these people with. So I guess I have a two-part question. One is, why aren't the existing laws on the books sufficient? And second, what happened in Mrs. King's case? Were any people prosecuted under existing laws for their conduct?
We felt like it was necessary to go on the record with this and to join other states in doing something to protect families from this outrage, is what it is. As far as anybody being charged from demonstrating Mrs. King's funeral, I have not heard whether they were or not. I haven't heard. If they were, I haven't heard about it.
But could these protesters couldn't they be prosecuted under the existing laws on the books? And some of these, like terroristic threats, would be a felony.
I assume that they could be.
Mr. Representative Setzler.
Thank you, Mr. Chairman. Isn't it true that, again, I'm strong in support of the bill here, Senator Douglas, and just listening to some of the discussion, I recall some funerals I've been to before. My grandfather, for example, in 1997 was buried in a small town cemetery that was not more than 200-300 feet across, and it was on the corner of a street, and had there been demonstrators 100 feet away from the property line, would have been no more than 150 or 200 feet away from us.
That's right.
Certainly would have been within earshot. Certainly would have been within view, and as is the case with most folks, or with many folks, certainly not all, funerals can be more than just remembrances. In some cases, funerals can be religious services, and I've got some concerns with respect to interrupting a service of a religious experience that's a religious experience for folks of many faiths, and I don't see this as being an undue restraint against speech, particularly understanding that 500 feet is less than a tenth of a mile away, I think we'd be well advised to vote green on the bill.
We felt like, and I appreciate those comments, we felt like that, and I do feel like that if something, and to my knowledge, there's been threats of these demonstrations in Georgia. There was a funeral in my district where there was a threat of a demonstration, and then there was one in Savannah also. But I don't know that they've materialized. But we felt like that if something like this was to happen in Georgia and we did not act, that it would be difficult, frankly, for us to look the family in the face if they said, why didn't you do something to stop that? And so that's the purpose of this bill.
Chairman Knox.
Senator Douglas, would this apply in the case of, say, Jane Fonda's funeral as well?
Can you get back with me on that? We can't be selective.
Representative Abdul Salam.
Senator Douglas, thank you for your comments and your observation. I think that I know for a fact that I was in the car with Mrs. King's family, including some of her young relatives, nieces and nephews, and cousins, when we passed by the demonstrators. And it was horrible. But I don't think that there was any discussion about who these people were. Until you said it, I didn't even know who they were. But with the amount of cameras and media attention, I'm sure it's easy to go back and identify and prosecute them under some of the statutes that are currently on the books, since we know who they were. I guess my concern is that the language that you read and that we saw on those signs at Mrs. King's funeral is also multiplied 100 times over on the blogs and on the internet. So would we then go after that next?
Thank you for the question. But I think that sitting in front of a computer and looking at something is not the same thing as trying to walk into a funeral site and have signs waved in your face when it's your family member, frankly. And so I'm not sure that I see the correlation there. Certainly there are awful things on the internet, blogging and everywhere else on the internet. But again, what we're trying to do is to ensure that families in this state don't have to put up with such the indignity and the disgraceful behavior that you saw and that have been seen in other states. And you see from this flyer how repugnant and vile these people are. And so, again, they deliberately target people at the height of their grief, going to a funeral, to try to be disruptive and to try to make their point. And I'm not telling them they cannot make their point, and I don't think Mrs. King would have told them they can't make their point. All we're doing is trying to say that you're going to have enough courtesy to the family that you can say what you want to say, but you're going to do it 500 feet away.
Representative Maynard.
Senator, thank you for bringing your bill. I have very mixed feelings about this particular bill. I too am a guardian of First Amendment only because of democracy. In America and some other terroristic, some people that are living under terror is the way we resolve differences. And in America right now, we are at a crossroads where we do have certain people that are trying to silence the opposition, even in this House of General Assembly. In this General Assembly, even with the Hawk system that I vehemently oppose, because we can have 10 people against something, you can bring in 12 people to outvote us and to silence the minority vote. You have interestingly brought in Mrs. King today. I was at that funeral, and interestingly, there were some people trying to keep me, I'm a representative, keep me out of the Capitol to show my respects. And there were people of power. And the problem with this bill is, not that it's not a good thing. I'm a person of faith. And I do not allow, or I don't appreciate people doing disruptive things. My concern is not that we should not have people that are not doing disruptive things. My concern is what would the abuse of this law is what I'm concerned with. Because I don't think anyone should be disruptive at a funeral. And I was trying to think, well, what would be acceptable? And you said 500 feet. It was 100 feet. And what my concern is, a football field is 300 feet. So you're basically taking a football field
And a half.
and about a half that you can be away. I don't know what's acceptable, but there's something that I cannot articulate to you today that I don't like about this bill. And it started with, and I guess this is what I'm trying to say, and I like for everybody, one of the problems I have is I hate biting my tongue. I do. I hate scratching where I don't itch, and shuffling and dancing when it's not, you know, I hate it. And see, with all due respect to the author of the bill, when you bring in Coretta Scott King to defend this bill, it was repugnant to me personally. Why? Because Dr. King died trying to give the dissenting voice, because he did oppose power. He spoke truth to power. And these people, that's what it is. These people are so frustrated. They're doing things to show displeasure with a system, but they have to do it with some decorum. I think that is proper. But we must not, in America, make this such a system where the opposition has no voice. And that's why it becomes disruptive. When the opposition has no voice, we are no different than when a dictator is taken down by violence. So the principle I'm trying to espouse to you, and this is more of a message, and it's really venting because this bill is going to pass. But with all due respect to you, maybe a football field, maybe that makes a difference, it doesn't make a difference. My point is the direction in which you're going in. Your direction is to oppose anyone who is opposing, for example, a war. You'll fight with Jane Fonda. You know, we make a joke of it now. But Jane Fonda did something that was really repugnant to many people. But at fundamental, and she did it in a way that may not have been proper. But what we must do in America is preserve an opportunity to dissent. That's the only difference between the dictators who have a coup to take over the next government rather than have a peaceful vote. So what I'm suggesting to you is today, thank you for bringing this, but it doesn't smell good, particularly when you bring in Ms. King, particularly what happened on that day when the people who have an opposing view than I on some issues did not want me to be around Mrs. King. I was, and I have a relationship with her people. I was a member of that church, of Ebenezer. Basketball and Marty King. And and there were people that don't look like me trying to keep me away from them. I'm not worried about these people that don't have power to make their voice count. I'm worried about the ones that do have power and are squashing it. And the government is now squashing First Amendment. And the first the ACLU, we fight on some things. And I've been on the same side. Even a clock is right once or twice a day. But they're wrong on a number of things. So all I'm suggesting, sir, is the way this is written, when I try to get to my point is, 500 feet, I'm trying to think, can you see people from 500 feet?
Sure.
If you're passing them. I don't have a solution. It's just, and for all persons here, I went on a little longer than I wanted to. It's just that I'm a little frustrated because I love America, and if we speak anything against George Bush, you got people that come on like swarms of black bees to attack him. That's not America. Allow the opposing voice, but at the same time, I respect George Bush. In fact, I pray for him. I respect him, and I disagree with people who disrespect him. But I'm trying to say we don't need people disrespecting people at funerals, but fundamentally you are on the edge of squashing free speech. And so when the ACL comes in here, I'll listen to what they have to say. But I am a little concerned at the direction that we're going in. And thank you, Mr. Chairman, for allowing me to go off, because I went a little further than I wanted to.
Let it be noted, that the First Amendment is alive and well in this committee. Wouldn't you agree?
It is.
I was thinking you were going to disclose to us that you had actually voted for the president. So.
I can't give you that. In fact,
that's all right. That's okay. Catch your breath, Representative Mangum. I'll come back to you. I'm going to go ahead and Ms. Garrett from the ACLU had signed up.
I apologize, my cough has not gone away since yesterday. My name is Maggie Garrett. I'm the Legislative Counsel at the ACLU of Georgia, and we are here to oppose this bill. I will condense my points from yesterday.
Thank you very much.
Yes. There are three main points I want to make. First of all, as distasteful and offensive as Fred Phelps is, his speech is still protected by the First Amendment of the U.S. Constitution. And this bill is unconstitutional. A 500-foot zone is blatantly unconstitutional. The largest zone ever upheld by the U.S. Supreme Court was 36 feet. And in that case, they held up that zone because there were protesters who were blocking an entrance to an abortion clinic, and they had been told more than once that they had to stop blocking that entrance, and they didn't. And what the Supreme Court said was that this was a small enough buffer to allow women to enter and exit, but at the same time allow the message of the protesters to be heard by the women entering and exiting the clinic. And I think it's important to note that the justices who actually dissented on that case and said that 36 feet was too big were Scalia, Thomas, and Kennedy. Those were the judges who said that no buffer zone is allowed. There have also been cases where the Supreme Court struck down a 300-foot zone. There's a case in the 11th Circuit where they struck down a 200-foot zone. This, as you can see, is much bigger than 36 feet. It is much bigger than 300 feet. It is much bigger than 200 feet. In addition, this ban is extraordinarily overbroad. It doesn't just apply to people who are protesting the funeral. It could apply to a labor union who is picketing the labor practices of a cemetery. This could apply to people coming to the Capitol, walking silently with a sign in front of the Capitol, who find out that the Presbyterian Church across the street is having a funeral in an hour, and they can't protest a bill that's up on the floor of the House. This applies to people marching down the street of Atlanta. Before they can march, they have to check with every single church, every cemetery, every funeral home along the route to make sure that they haven't scheduled a funeral for that day. And as you know, funerals are not things that are planned long term. So if you're planning a march in several months, your march you may find problems because you can no longer take your march because one of these churches has a funeral. So it's causing lots and lots of problems. And I think that it's important to understand that this is unconstitutional. Fred Phelps has several attorneys in his family. They will sue to challenge this, and when they win, you will be giving attorney's fees to Fred Phelps and his family, which will just give them more money to fly to Georgia to protest more funerals in Georgia. There are other ways that we can deal with this. Some states have changed some of their disorderly conduct laws to make clear that it applies to funerals. You can apply laws that we have currently, such as trespass laws, fighting words, threats, all sorts of things like that. And I urge you to not pass an unconstitutional law when there's other ways we can deal with this issue.
Questions for Ms. Garrett? Representative Setzler.
Hey, Mr. Chairman. Ms. Garrett, appreciate you coming today to share your thoughts with the committee. I'm looking on page 1 of the bill, line 18, and I wanted to speak to what you raised about unintended consequences with respect to a funeral being across the street at the Presbyterian Church. As I read line 18, it shall be unlawful to engage in any disorderly or disruptive conduct with the intent to impede, disrupt, disturb, or interfere with the orderly conduct of any funeral or memorial service of the normal activities and functions carried out in the facilities or buildings where such funeral or memorial service is taking place. A protest or a peaceful protest or picketing in front of the Capitol is not done with the intent to impede, disrupt activities within the Presbyterian Church. So I'm not sure that was just an oversight on your point, on your part, or please advise.
As I read the sentence beginning on line 21, it says, any or all of the following shall constitute such disorderly or disruptive conduct. The way I read that is when they say such disorderly or disruptive conduct, they're saying the disorderly or disruptive conduct with the intent, et cetera, et cetera. So when you look at the list of 1, 2, and 3, and 4, all of those are presumed to meet the definition of disorderly or disruptive conduct with the intent to impede, disrupt. That's how I read that. So because they say shall constitute such disorderly or disruptive conduct, I think that may answer the question.
Chairman Knox.
In light of what your concern is here, is your objection just to the bill in general and to the idea of the bill, or do you have specific complaints other than what you've just said about the bill?
I think the best way to deal with this is to work through our disorderly conduct legislation, which I don't have in front of me. I don't know that even changing it to 100 feet will make it constitutional because it's still way beyond the bounds of what the Supreme Court has upheld. I mean, the one case where they have upheld a buffer where there was no prior misconduct that the court dealt with was 8 feet. And that, again, is something that Scalia, Thomas, and Kennedy said was unconstitutional. So I'm not sure that even changing it back to 100 feet would help. I think it would still be a problem.
Well, suppose we took buffer out altogether. Suppose we took the buffer out of the bill altogether. Then what's it do for you?
I'm trying to figure out how that would work.
Well, my point here is that not all speech is protected by the First Amendment. You can't yell fire in a movie theater and some things like that. That being the case, it probably also is not permissible for hoodlums to go running through a cemetery and causing havoc while there's a funeral going on. And so I think the intent of this bill is to limit behaviors that are directed specifically at this function. In other words, this is something that our society recognizes as a sacred, honored part of our customs of the burial of a deceased.
Right.
So, I'm sorry?
Private.
Yes. So that being the case, if we eliminate the buffer problem that you're talking about, don't we have a bill that would pass constitutional muster then?
I guess I'm having trouble figuring. I mean, to me, when I read this bill, the whole bill is about the buffer. I mean, there's a buffer of Section 1, there's a buffer of 500 feet, you can't do this. Number 2, there's 500 feet, you can't do that. C, they're all blocking speech issues. 4 is perfectly fine. And I believe that we already have laws in place saying that you can't block pedestrian or vehicular access. 2, I think, is probably fine because it talks about fighting words. I think the real problem comes in Section 1, which applies to all protests, all types, whether it's walking silently with a sign or whatever.
You're speaking there of, and let me interrupt because I want to find out where you're speaking line 23 in particular, or are you talking about the entire section A, B, and then 1?
I'm talking about section B1, I think, is the biggest problem.
Okay. But would you agree that there are already on other grounds one could be
prevent it from using fighting words, abusive language, that sort of thing. They're objectionable on other grounds, whether it's a funeral or whatever it is. So there would be grounds for that. So it seems to me that you're focusing in primarily on this section B1.
Yes.
And that's primarily due to the issue of the buffer.
Right.
Correct? So if we took the buffer out of this, does that satisfy, if we took the buffer out, does that satisfy your concerns about...
What do you mean by take the buffer out? Do you mean reduce it to
I'm talking about,
zero or just...
Yeah, right, exactly. Not having a buffer at all. Just saying, if your behavior is directed at disrupting and disorderly conduct for the purpose of disrupting or defiling the ceremony that's taking place, that's objectionable, and this law would prohibit you from engaging in that kind of conduct when it's for the purpose of doing that, from disrupting or dishonoring and creating havoc at this function.
Right. I think that's a better way to do it. Sort of off the top of my head, I'm not sure how the language would work, and I think that there are some times when that could actually conflict with some free speech issues. But I think I'd have to see. In some of the disorderly conduct laws that have recently passed, some states have decided to do it through disorderly conduct statutes rather than doing it this way because of the free speech implications. I think it can be done. I guess I'm sort of trying to wrap my brain around, if you took out the 500 feet if you just removed 500 feet, wouldn't that say then that you can't have a parade all the way up to it? I guess I'm
saying. I guess what I'm saying is it doesn't make any difference how close or how far away you are. That's really not the issue. So whether it's 500 feet, it's 100 feet, or it's no feet, if you're doing something that dishonors the ceremony that's taking place and abusing by these means that are enumerated in this bill, that can be objectionable, and it could be enforceable under law. You could be prevented from doing that.
I think
even on other grounds.
Dishonoring, I think, might be a little vague for free speech implications, but I think that disrupting, I think there are already statutes on the book that would prevent that. Yes.
Okay, but this bill in and of itself, if that was the purpose of it, other than the buffer zone requirement in here, is not objectionable on First Amendment grounds.
Right. Yes, I think I understand what you're saying. I understand the intention. It's not a bad intention. It's the implications for free speech that is the problem. Exactly.
Thank you, Mr. Chairman. To the witness, talk to me for a moment about what public assembly means. If the several of us gather together and stand on a street corner, do we have to say anything or yell anything in order to be publicly assembled?
Actually, that's something that has been litigated. There is no definition in here of what they consider to be public assembly. In the Martha Burke case down at the Masters several years ago, that was actually a big issue because they were requiring permits for public gatherings of 5 people or more. And the issue became, how do you tell whether it's a protest? If you're all wearing, Go Tiger Woods buttons, are you protesting? And the court said that yes, you could be considered to be protesting. So, and when you talk about picketing, it could be one single person advocating for a particular issue. So you could be walking down the street with a sign. You could be walking down the street with a button that says something, and that sometimes can be construed as protesting.
Right, but forget about protesting. You may mean the same thing, but to publicly assemble, do I have to say anything verbally?
I don't believe so.
Do I have to hold up a large sign?
I don't believe so.
Then, under what this bill prohibits under Section B1, line 23 on page 1, the several of us under this bill could not simply stand on a street corner 499 feet away, not say anything, not raise any sign. We simply could not assemble there.
I agree with that interpretation. I think that's true.
Thank you. Is that constitutional in your opinion?
I believe it's not constitutional.
All right. Thank you.
Senator Douglas has to be recognized.
Go back and address 2 items. One item brought up by Representative Knox. If you take 500 feet out of this, then you could have an overzealous sheriff arrest somebody 2 miles away for holding a sign. be perfectly within the law if this bill is passed. The other thing that I would remind the committee of is that when the G8 conference was held at Sea Island, not only were they not allowed within 500 feet of the hotel, they weren't even allowed on the island. They were kept back on the mainland. As to my knowledge, there were no court cases, no challenges to that, and life went on.
Well, can I clarify that, Mr. Chairman?
Sure.
My point being is if I've got a good loud inhaler, I can be heard from more than 500 feet away, and I could pretty well disrupt that gathering. So my point is that I think your bill is about not letting the funeral be disrupted, not preventing, and the distance is not the issue. The issue is whether you're doing it or not. So what I'm saying is 500 feet doesn't really get it for not causing, because the real issue is we don't want you disrupting funerals, causing funerals to be held up, or people being subjected to abusive language and so on and so forth. It doesn't make a difference where you are. If you can be heard by that group and you're doing it for that purpose, this is what you want to prevent in this bill, regardless of where they are.
Representative Setzler and then Representative Everson.
Hey, Mr. Chairman. In staying with the author's intent of I think, public policy intent, I think I can speak for myself in saying I'd like to help you achieve that, Senator Douglas. I don't know that I agree with the witness's reading of the language, but I will propose, at least for discussion, something. Again, getting back to page 1, line 18, disorderly or disruptive conduct with intent to impede and so forth. As I read down on line 22, it says, shall constitute such disorderly or disruptive conduct. I think, as I read it, and I think you're probably reading it, such disorderly or disruptive conduct brings in the with the intent to impede, disrupt, or interfere, and applies that to these definitions. If it were to read, I'm just for purposes of discussion, if line 22 were to read, following shall constitute disorderly or disruptive conduct in accordance with this code section, then on line 18, that which would be disorderly or disruptive conduct would be enumerated below. But unless that conduct enumerated below had the intent to impede, disrupt, disturb, or interfere, it wouldn't be overly broad in accordance with your definition, wouldn't apply to a demonstration in front of the Capitol in terms of its impact across the street of the Presbyterian Church. If you simply struck such, and after disruptive or disorderly or disruptive conduct, insert it in accordance with this code section. Would you agree with that reading of it?
Yes.
Okay. So I'm not making that amendment now, but I think in keeping with the author's public policy intent, I might be prepared to make that amendment at a later time, Mr. Chairman.
Representative Everson.
Thank you, Mr. Chairman. I'm somewhat I don't know what's the correct terminology, but I'm somewhat surprised in the regards that Senator, the bill passed the Senate, 55-0. And even Senator Ford, who was a board member of the ACLU, voted for this bill.
That's right.
To the ACLU witness here, in your opinion, and I'm a big defender of freedom of speech, is there anything not sacred anymore in America?
Well,
when it comes to saying goodbye to a loved one, is anything not sacred anymore in America?
Well, I can answer that, I think, in a couple of ways. First of all, I think it's somewhat important to realize that in a lot of these situations where there is a funeral in a cemetery, it's inside of a private cemetery. So these protests are actually happening outside the cemetery. And what this would do is have the buffer zone actually go from the corner of the edge of the cemetery all the way out. So it's not a situation where Fred Phelps is standing right there, first of all. Second of all, I think that sort of already the marketplace of free speech has been solving some of these problems. In the case of Fred Phelps actually only used to target people who were gay. He's anti-gay, he's homophobic, and that's why he does these protests. So back when he was only protesting gay people, they had angels that would show up, and they would be dressed as angels, and their wings would go up, and they would protect protect the people in the funeral from seeing Fred Phelps. What's happening now at the military funerals is there are volunteers who show up and they wave their American flags so that there is a buffer between Fred Phelps and the funeral, but the buffer is by people and by speech, not by the government. And so they're protecting it in that way. And I agree that what he's doing is offensive. And I think that there are ways to deal with the fact that what he's doing is offensive. But I think that going in and violating the U.S. Constitution is not the way to do that. I think that there's ways other than preventing people from speaking.
Okay, Mr. Chairman, a follow-up, one last question here. As I listened to my esteemed colleague, Representative Knox, mention about the reduction of buffers, in your opinion, if the buffers were removed, do you honestly feel that that would create unintended consequences? I'm attempting to paint a picture here. I'm saying goodbye to someone that I love. I have family members and other loved ones assembled around this sacred area. And you're allowing someone to come in and protest. Do you not foresee unintended consequences? I'm just asking.
Unintended consequences of letting people protest?
Emotions?
Oh, well, I mean, there are situations, if it's going to be a heightened situation, police can protect them, things like that you can bring in police, you can change permit situations around if you're concerned about hostility rising. But under the First Amendment and under case law under the First Amendment, the fact that it's unpopular speech does not prevent you from being allowed to have a protest. So what they call the heckler's veto, that someone might be offended and might yell back at you. A heckler cannot prevent someone from having their own free speech rights. The police may have to come in, they may have to separate them some, they may have to put in some reasonable regulations to prevent something like that happening. But you can't prevent someone from speaking just because other people don't like it.
Senator Douglas, I want to thank you for bringing this legislation, and I want to go on the record, I support it. And to my esteemed colleague, Representative Mangum, as far as finding it repugnant, I hope you have that same feeling when we discuss illegal immigration, when it's being viewed as the same method that slavery was viewed in.
We're not on that bill yet, Representative Everson.
Thank you.
Chairman Knox.
Let me be sure. You mentioned the issue of if there's a demonstration going on at the Capitol, for instance, there also has to be a funeral going on over at the church across the street. That was what you're getting at. Whether or not the difference there being that there has to be some intent to act to disrupt or cause harm to the service that's in process. It can't just be an ancillary or a collateral type of disruption because of something going on somewhere else.
Well, as I read this bill, you don't have to be targeting the funeral because, excuse me.
I think that's completely incorrect because it says interfere with the orderly conduct of any funeral.
When you read, I'm sorry.
No, I'll come back to you. I understand. One at a time. The question was to the witness.
If you look on line 18, although it does say it shall be unlawful to engage in any disorderly or disruptive conduct with the intent to impede, and it goes on and on. When you look at line 21, the ending sentence there, it says any or all of the following shall constitute such disorderly or disruptive conduct. So I read that as they're assuming that intent if you do any of these things.
Representative Benfield.
I would just like to hear Ms. Garrett's response to the 500-foot barrier at Sea Island, and whether that was litigated, because I know the ACLU was involved with that, and I just can't remember what happened.
We actually brought 4 suits. I guess there were 2 separate suits against different counties down there, and we did challenge some of the restrictions put on the demonstrators. We did end up settling the issues and settling on some of the ordinances, so that there were protests in Savannah and and in Brunswick County, I think, Boone County and Brunswick County. So we ended up settling, but there were lawsuits filed over those issues.
But now, but the Savannah is how far from Sea Island? We had demonstrations in Savannah. Savannah is 75 miles from Sea Island.
Okay. Representative Benfield.
Was there a court determination that 500 feet was
Well, actually,
constitutional, or was it just you settled out of court?
in those cases, we were basing the protesters that we represented wanted to protest in those areas, and so there really wasn't an issue about 500 feet. It was issues about who needs to get a permit, where they can protest, where they can't protest, and both of those cases were settled.
Okay. I'm thinking about it. For a concise comment on this bill.
I believe that the intent of this bill is good. And that's why I said it goes on the edge. And it really comes on how it was presented. And I know this is really to get to people that are protesting the war, I believe, from what I'm gathering. Which I don't believe it is a good thing for anyone to go and protest these people's funerals. And I think that we must have some things that we draw a line to. I would try to support whatever my good friend, my distinguished colleague, Mr. Knox, can draft up that would be constitutional. And I was even trying to say, I would rather that the sheriff, I would trust my law enforcement officers, Mr. Judges, that if they locked up someone 2 miles away, that he would have to just prove his case that they were trying to be disruptive, rather than have these presumptions of disruption. Because if I'm 500 feet away, I was trying to put in my mind, and I still, I have not identified what is so repugnant about this bill, except that it does go in the direction of squashing free speech. But I do believe we do not have the right to scream fire in a crowded theater. We don't have the right. So, to the extent that America calls on God when we have emergencies only, I don't think we should allow people to come in and disrupt funerals. So to the extent that anyone believes that I'm saying we need to allow people to disrupt funerals, that's not what I'm saying. I'm saying that the 500 feet, I guess that was really when you try to put a point on it, you try to analyze it, the 500 feet, the buffer, maybe that's what I'm having a problem with. Because you say 500 feet, you can't have a dissenting voice. My question is, could you trust our good law enforcement officers if you put a period on line 21 at the end of the sentence where you just said, whereas such funeral or memorial service is taking place? I'd rather for the officer to be overzealous and lock some people up, and we have to have a factual basis before a jury and let the jury decide. Clearly, you were 2 miles away. You could not have meant to disrupt this funeral. Or you were standing 1 foot away and you did whatever and it was disruptive and you really didn't mean to. But we think you did mean to, and that's a factual decision. So I know you've done a lot of things, and you have a passion for protecting our soldiers, and I thank you for doing that because we have to protect our soldiers. And I do think it is disgusting that this guy goes around and targets these families. That is repugnant. The thing that is repugnant is 2 things in this bill. I want people to feel free that they can speak, but at the same time, there is a line. You can't speak and come into my house and take over my household. These are my rules in my house. If you're going to come in, I invite you, regardless of the race, religion, whatever. But when you come in my house, you're under my rules. I guess that's what I'm trying to say. And what I'm suggesting is the house rule is the code now. And if you say 500 feet, I'm concerned that what we say is unintended consequences. So how do you feel about putting a period there and trusting our law enforcement officers to determine, because it's going to be hard to determine every factual circumstance situation. And I am thinking about Dr. King, and I am thinking about someone abusing the laws to say, well, you were 499, or no, you were 501 feet away. No, you were 499 feet away. I was not. I was being very respectful. Okay? And I'd rather for that to be a factual question rather than a presumption, because with the way I'm reading this, the young lady from the ACLU is correct. These are presumptive disturbances. If I am in a group 500 feet away, it is presumed I am guilty, period. Versus, and I know you don't intend that, but there could be some people that are there unrelated. So my question is, if they're being disruptive, I think an officer is able to say you're being disruptive and just lock them up. I'm with you for that. But if you're saying that you were blocking this and blocking that, that's disruptive. It's a fact. Can we trust our officers to that extent?
Further questions? Further questions? Representative Setzler is recognized.
Chairman, would you let him answer that question?
Which one?
It was a question.
Which one?
The question was, at line 21, we put a period there.
I'm sorry.
And trusted our law enforcement officers so that I'm not in favor of giving these people any money who come into these places. If they're using the system together to extort money from the government, I'm against that. So I don't want to give them money to win a case that we know we're going to lose.
Okay, let's go back to the question. Senator Douglas.
Period at line 21 on first page, and trust our law enforcement officers to exercise discretion.
Approve or disapprove?
Disapprove. And the reason is that we've got the bill. Now you put back funeral processions into the bill because it's solely on the judge and the law enforcement as to whether they're going to enforce the law and how they're going to do it, which the Attorney General has already specifically told us they thought that would not stand up in a court of law. But now we're opening that to the subjective opinion of law enforcement. You're also, again, as I go back, when you throw out the 500-foot buffer, if you've got an overzealous law enforcement out there 2 miles down the road, somebody holding a sign, they're going to say, get them, that kind of thing. So I think in a backdoor way, what we're doing by doing that is guaranteeing that the bill will never survive.
Okay. Thank you for answering Representative Mangum's question. Representative Setzler.
Thank you, Mr. Chairman. I'd like to offer what I hope will be a friendly amendment to the author. For purposes of preserving what I believe to be his public policy intent, and recognizing the unintended consequences brought by the witness. I understand the witness has some other concerns from a public policy standpoint, but purely for the issue of unintended consequences. And again, using the case of protesters in front of the Capitol who are protesting for some other purpose, being deemed, as the law is currently written, to be protesting a funeral in the Presbyterian Church across the street. I would propose on lines 21 and 22, striking, beginning on line 21, any or all the way to the end of line 22, striking that sentence in its entirety, and substituting in its place, for purposes of this code section, comma, any or all of the following shall constitute disorderly or disruptive conduct, colon. I'll read that again. For purposes of this code section, comma, any or all of the following shall constitute disorderly or disruptive conduct, colon. What I believe that would do, and what my intent is, it would define the 4 categories enumerated below as being disorderly conduct, as referenced on line 18. But any of those 4 enumerated would have to be done with the intent to impede, disrupt, disturb, or interfere with the funeral or so forth.
Let's do this. Is that an amendment?
That's a proposed amendment, Mr. Chairman.
Do we have a second?
I was going to ask if there's a friendly amendment.
Okay, well, I'll recognize him, and then we'll see if you can get up a second.
I'm having a hard time understanding how that changes things.
Okay. What, Senator Douglas,
Well, let's see if you get a second first, Representative, and then we can have discussion. I think you've done a good job of explaining it. Is there a second to the amendment which the author has some concerns about?
Can I explain it further, Mr. Chairman?
Well, you've had one shot. Let's make it brief.
Okay.
I'm giving you two shots to explain your amendment. See if you can get a second.
Does the author understand?
Add for the purposes of this code section, and then go ahead with the sentence that's already there.
As the bill is currently drafted, any or all of the following shall constitute such disorderly conduct.
Okay.
With the word "such" in there, it says any of the following four shall not only be disorderly or disruptive conduct, but it will be disorderly or disruptive conduct with intent to impede, disturb, disrupt, and so forth. If any of that stuff is existing within 500 feet, but is not done with the intent to impede, disrupt, or disturb, as it's currently written, I believe it would be.
Might as well have a discussion.
All right, now you've gotten a second. You want to continue with your discussion?
Okay. I want to make sure you understand it. Okay.
So you want to drop the word "such"?
In essence, I'm looking to get rid of the word "such," but I think it could be reworded to be even made more clear. But the word "such" is what.
Okay. I wouldn't have a problem.
If on line 18, if you were to put brackets around disorderly or disruptive conduct.
So the line would then read, any or all of the following shall constitute disorderly or disruptive conduct?
For purposes of this code section, you might want to add in. Because we're not looking to redefine disruptive conduct across the code, but for the purpose of this code section.
Well, that was your motion. That it would read for purposes of this code section,
comma,
the following shall constitute disorderly or disruptive conduct.
Yeah, I was just reordering the sentence.
All right, I have no problem with that, Mr. Chairman.
All right. Okay. Well, we have the motion. Now we have an objection. So is there any further discussion on the Setzler amendment? Hearing none. All in favor of the Setzler amendment, please indicate by raising your right hand. All opposed? The amendment fails. Representative Jacobs, did you want to be recognized?
Yes, Mr. Chairman. Well, I disagree with Representative Mangum with regard to cutting off sub B at line 21 at the end of the sentence there. Just wanted to float the idea out there of, I mean, you know, there is a concern has been expressed about chilling free speech and about the constitutional implications of that. I mean, I certainly consider the conduct that is described in subsections B2, 3, and 4 objectionable, but I'm not sure that the conduct described in subsection B1, it's possible that the conduct described in subsection B1 is, or I'm sorry, that the scope of subsection B1 is overly broad. And so I'd like to get the author's feedback on that. I'm not at the point of proposing an amendment, but I do want to pose the question.
Thank you for the question. I appreciate it. It goes back to previous wording that says, that indicates that subsection 1 there would only be unlawful if it was designed to engage in disruption of the funeral. You know, everything. Let me see. Everything below subsection B there shall be unlawful to engage in any disorderly, disruptive conduct with intent to impede, disrupt, disturb, or interfere with the conduct of the funeral. Everything after that pertains to those two lives. So subsection 1 would pertain to conducting a public assembly, parade,
Let's give the
demonstration,
senator
light
some
event.
order, please.
Would pertain to conducting a public assembly, parade, demonstration, or like event that was designed to impede, disrupt, disturb, or interfere with the funeral.
Yeah.
So that's why it's in there.
I'll have to think about that, but I take it that means you would object to such an amendment that would strike
Section 1?
Yeah.
That's correct, yes.
Further questions? Recognize Representative Bearden for a motion.
Mr. Chairman, I would ask that the committee do pass Bill 606.
We have a motion that Senate Bill 606 be given a due pass recommendation by this committee. Is there discussion on the motion? Chairman Bordeaux.
Is this the time for further attempts to amend?
Sure.
Move to amend Senate Bill 606 by striking subsection B1 in its entirety and renumbering the sub-paragraphs according.
Does everyone understand that amendment? Anybody got any questions about the Bordeaux amendment, which would strike essentially on page 1, lines 23 through 26? That entire subsection. Okay. Is there a second? We have a motion that we adopt an amendment moved by Chairman Bordeaux to strike subsection B1 on page 1, lines 23 through 26. Is there discussion on the motion? Well, there's been an objection. We're going to have.
May I make a brief statement?
We're going to have a vote. Chairman
Thank you, Mr. Chairman.
We're in discussion.
Very briefly, I'm proposing this simply because I believe that as a legislator I have an obligation not to pass legislation which I think honestly is clearly unconstitutional. Passing this will cost the state a lot of money. We will lose the bill. We will lose the court fight. The people we're trying to stop will benefit from it. We will suffer from it. So, I'm just doing what I think I've got an obligation to do. If you all feel differently, I respect your opinion.
Okay. Further discussion on the motion. Representative Bearden.
Unless I'm mistaken, I believe it's our job as a legislature to pass law and let the courts decide if something is unconstitutional, but it's our job to pass what we feel is correct.
Further discussion? Hearing none, Chair calls the question. All in favor of adopting the Bordeaux amendment to Senate Bill 606 will indicate by raising your right hand. All opposed? Bordeaux amendment is adopted. Further discussion? Further discussion? Representative Mangum? Excuse me? Are you making a motion?
Making a motion to reconsider.
We have a motion to reconsider adoption of the Bordeaux amendment. All in favor? Or is there a second?
Second.
We have a motion that we reconsider adopting the Bordeaux amendment. The chair will not entertain discussion on that. All in favor of the motion to reconsider indicate by raising your right hand. All opposed? Okay. Motion is lost. Okay. Is there further discussion now on the motion, which is to give Senate Bill 606 a due pass recommendation now as amended? Is there further discussion? Representative Mangum.
I move to pass on Senate Bill 606
Is
amended.
Is there a second? Is there a second?
Second.
Well,
Mr. Beard has already made.
Yeah, I think there's already been a motion.
I'm going to make a motion to pass with this now.
I think he's withdrawn his motion. So we're back now to the Mangum Knox motion and second to give it a due pass recommendation. Okay. Any discussion on the motion?
Mr. Chairman, I'd like to...
Representative Setzler. Representative Setzler is recognized.
Am I in order? Was a motion?
Sure.
I'd like to propose a... Give me 1 minute, Mr. Chairman, make sure I get my wordsmithing correct. Mr. Chairman, can I speak to the office very quickly?
Well, we've spent a lot of time on this bill. Let's wait till the author comes back. Okay, let's come back to order. If I could have some order, please. Recognize Representative Setzler.
Mr. Chairman, I'd like to propose an amendment to change on the references to 500 feet to 550 feet and reinsert conducting public assembly for the language we just struck in the Bordeaux amendment, but with 550 feet.
Everywhere in the bill, 550 feet.
I'd like the language that was struck on lines 23 through 26 of the bill to be reinserted with 550 feet. And the reference to 500 feet on lines 3 and 9 on page 2 to be reinserted to also say 550 feet.
Let me see if I understand your amendment. I understand that you're now wanting to amend to put back in B1, but are you wanting to change everywhere in the bill where it now reads 500 to 550? Because that's also on page 2, line 3 and line 9.
Let me defer to the author. Would that be a friendly amendment?
Mr. Chairman, I would recommend that we do reinsert B1, but maintain 500 feet.
Mr. Chairman?
Chairman Franklin.
I propose an amendment on page 2, between lines 13 and 14, paragraph 4, to read, conducting, it would be open parentheses, number 4, close parentheses. And if you'd like to follow along, I'm going to be reading from lines 23 to 26 from page 1. Conducting a public assembly, parade, demonstration, or other event, either fixed or processional, within 200 feet of the ceremonial site or location being used for a funeral or memorial service at any time 1 hour prior to, during, or 1 hour after the posted time for said funeral or memorial service, period.
All right, we have two different amendments out here, neither of which has been seconded.
It's the same language. You can't do that. Procedural object.
Yes. Are you insisting on your amendment?
Mr. Chair, I would like, I'd like Representative Franklin to reread his and
Okay, listen up.
Basically, all my amendment does is take the language that we struck from page 1 and insert it as the new number 4 between lines 13 and 14 of page 2.
I withdraw my amendment, Mr.
Is there a second to the Franklin? We have a motion. Recognized Chairman Bordeaux.
Assuming we're operating under parliamentary procedure, I think clearly the Franklin Amendment is simply an attempt to reconsider what has already been reconsidered once under parliamentary procedure. It is not proper to reconsider twice a motion already acted upon. Whether I agree with the Franklin Amendment or not is relevant. It's parliamentary. It's a blatant abuse of parliamentary procedure. It's out of order, and I would ask the chair to so rule.
I would have so ruled on the Setzler Amendment, but I'm going to overrule on as it relates to the Franklin Amendment.
Mr. Chairman, if I may inquire, sir.
Chairman Bordeaux.
My understanding is the Franklin Amendment is the only change. The Franklin Amendment simply moves what was subparagraph 1 that we deleted to be subparagraph 4. It's the exact same language, I believe.
I think that he had a different distance.
No.
The same distance? Okay.
It's exactly the same language.
I'm still going to stand by the ruling, and you're free to file a minority report or whatever. I mean, I would allow you to do that, certainly. You have that right. Is there a second? Was there a second on that?
Point of parliamentary inquiry, Mr. Chairman.
Vice Chairman Mumford.
Doesn't that require that, and maybe I didn't hear this, but wouldn't that require renumbering in the previous paragraphs? They already would.
I think he did that.
That was done with the first.
Any further discussion? Any further discussion? Hearing none, the chair calls the question. All in favor of adopting the Franklin Amendment indicate by raising your right hand. All opposed? And the chair breaks the tie in favor of the Franklin Amendment. Okay. Further discussion on the bill. Representative Bearden.
Bill 606.
Is there a second?
Second.
We have a motion that we give Senate Bill 606 by committee sub as amended a due pass recommendation.
Mr. Chairman.
Discussion on the motion. Representative Jacobs.
Point of parliamentary inquiry.
Yes.
Mr. Chairman, because we have reinserted the same language that was subsection 1 now as subsection 4, would it be in order, just to make things administratively easier, to do a substitute motion to move Senate Bill to move due pass on Senate Bill 606, not as amended?
Go back to the original version.
That's correct.
What's your reasoning for that?
It saves paper.
Does one need reasoning, right?
Essentially, it would prevent needing to reprint a different version of the bill.
Well, out of fairness, I'll recognize you for that motion.
All right, Mr. Chairman, substitute motion.
Representative Jacobs.
I move due pass on Senate Bill 606, not as amended.
All right. Is there discussion on the substitute motion?
Point of order, sir.
Chairman Bordeaux.
Either we passed an amendment or we didn't.
We passed the amendment.
And I respect the chair tremendously, as the chair knows, but I just can't fathom the chair's ruling on the parliamentary issue. But if we passed the Franklin Amendment, we passed it, and to adopt the Jacobs Amendment would be to restore, put us back to where we were to begin with, which would ignore the previous voters.
Several wrongs may make a right eventually.
Well, you could go around in a circle, perhaps, too. And I believe in the rule of law, as I know the chairman does, and I don't understand why we're forgetting about the votes we had.
And I respect that. I respect that.
And I would ask the chair to rule the Jacobs Amendment out of order.
I'll rule it out of order. And we have adopted, I think we have now completed Senate Bill 606. Excuse me? Final passage? Did we?
No.
Okay. All right. You had was there a Representative Bearden moved, Franklin seconded to give it Senate Bill 606 now as amended, final passage. All in favor, or any discussion on the motion? Hearing none, chair calls the question. All in favor of the motion, please indicate by raising your right hand. All opposed. Okay, thank you. Okay, we come back to order, please. Recognize Senator Goggins on Senate Bill 396.
Thank you, Mr. Chairman, and good afternoon, members of the committee. I'm going to try to be brief. It's going to be hard, but I know that time is waning for you. Today I'm going to bring to you Senate Bill 396. A little history real quickly. Last year, I watched with much interest as the state of Florida debated and passed what we now call as the Castle Doctrine law. Castle Doctrine is an ancient common law term, just says that a man's home is his castle, and he has every right to defend that home, whatever means necessary. So thus became the nomenclature of the Castle Doctrine. It's a very broad law passed in Florida, received a lot of support. So what I wanted to do, I took that bill and was interested in looking and see at how Georgia's law stacked up to Florida's law. But I was very surprised to see that Georgia has extremely strong laws dealing with one's ability to defend themselves. In fact, in the state of Georgia, a law-abiding citizen already has the right to defend themselves in their home. A law-abiding citizen already has the right to defend themselves in their vehicle, to defend themselves on their private property. They have the right to defend themselves in their place of business, even in the state of Georgia. An individual has the right to be a good Samaritan, to come to the aid of others, as well as come to the aid of police officers. We have a very strong law, but there was a couple of pieces of the puzzle missing that I thought that we could make it a little bit stronger, thus better for the victims of Georgia and the law-abiding citizens of Georgia. And so that's the reason I'm bringing Senate Bill 396 to you. And I want you to look. I think people have misconceptions when we start talking about the self-defense bill. This is a little over a page. It's only 3 sections. This is not a broad, comprehensive, wide-sweeping change into Georgia law. This is just about putting common sense into code. Common sense into code. In this bill, I have 4 objectives. And I'm going to go through the bill as we do our objectives. The first objective is to...
Mr. Senator, if you could hang on 1 second. What are you working from?
Substitute the Senate Bill 396.
What LC number?
It's 2287S. Is that it, Senator?
2287S.
Okay.
I have.
That's what I have.
Okay. I'm sorry. Go ahead.
Okay. The first objective is to extend the protection beyond the home, the vehicle, the business to, quote, any place where a law-abiding citizen has a legal right to be. For instance, jogging, walking, in a parking lot, outside your vehicle, do-it-yourself car wash in the alley. So there are many places that one may be vulnerable to an attack. And number 2, I wanted to put the current Georgia code is silent on the term duty to retreat. And we wanted to place that in code. So these first 2 objectives are taken care of in Section 1 of this bill, and I'll read it. It says, a person who uses threats or force in accordance relating to the use of force in defense of self and others, relating to the use of force in defense of habitation, relating to the use of force in defense of property other than habitation, has no duty to retreat and has the right to stand his or her ground and use force as provided in said code. So that takes care of the first 2 objectives that we had. The third objective was to make sure that those who stand their ground, as described in this bill, are immune from criminal prosecution, and that's covered in Section 2. So the person who uses threats or force in accordance with code shall be immune from criminal prosecution, therefore, unless in the use of deadly force such person utilizes a weapon or possession of which is unlawful by such person under Part 2 or 3 of Article 4 of Chapter. So that's the third objective. And the final objective, remember, we're just 4 changes here. We want to make sure that the ones we talk about in this bill are protected from civil liability, from being sued by the criminals, the attackers, the bad guys, or their family. And that's taken care of in Section 3. It says a person who is justified in threatening or using force against another under provisions of code relating to the use of force of self-defense, relating to the use of force in defense of habitation, relating to the use of force in defense of property other than habitation, has no duty to retreat from the use of such force, shall not be held liable to the person against whom the use of force was justified, or to any person acting as an accomplice or assistant to such person, in any civil action brought as a result of the threat or use of such force. So those are the 3 sections that cover 4 objectives in this bill. And I will note that we all have a lot of diversity. But I would also go on to say that I think that this law, it doesn't matter whether you're liberal or conservative, Republican, Democrat, young or old. Every law-abiding citizen in the state of Georgia should have the right to choose whether they want to stand their ground or flee. It's a choice. This does not say you have to stand your ground. It just gives you the right to stand your ground. This is about freedom to protect yourself, freedom to protect your family, freedom to protect your home. And it's about freedom from the fear of criminal prosecution for doing what you have every right, and you should have every right to do. And so I'm going to cut my comments short to answer questions, but I'm going to ask you to vote yes on this. And by voting yes, you're going to be looking after and taking care of the law-abiding citizens and the victims of this state. And voting no is going to be siding and coddling the criminals and the bad guys and the attackers that walk the streets of our towns and our cities. And I would ask for your favorable consideration of Senate Bill 396.
Thank you, Senator. I meant to do this before the break. If there are those here on Senate Bill 603, we're deferring that bill until tomorrow's calendar. So if you're waiting around on that, I wanted to, I guess the word got out. Thank you, Senator. Questions from the committee for Senator Goggins?
I do have questions.
Representative Byrd.
Okay, I want to be sure that I totally understand this. Actually, in my neighborhood, there is a pervert sexual predator, and he's been picked up twice in the last couple of months, and he's been following women that walk and jog and asking him all sorts of lewd things. So if I'm out jogging tomorrow and he approaches me and I'm carrying my gun and I feel threatened by him, would I have the ability to use it?
I think it all boils down to the term reasonable belief that this person is going to cause great bodily harm. And this is everyday happenings. And if you have a reasonable belief that this person is going to cause you bodily harm or death, then you have that right. But just idle threats or words, I would consider the right to use a weapon and take this person's life.
So now I can pack my spray and my gun. Thank you.
Representative Beard.
Just briefly, page 2, line 9. What is the key is justified in this whole thing, is it not?
Yes.
Thank you.
Chairman Knox. Chairman Bordeaux.
Thank you, Mr. Chairman. I have just a couple of quick questions. Are you aware of any statute under Georgia law, any court of appellate decision under Georgia law since the state was founded that says there is a duty to retreat?
The case law says there is no duty to retreat. but that is left up to the courts. I would like the legislature to make that decision so there is no changes in that.
But since the state was founded, the courts have always said there is no duty to retreat.
But if you can make a law stronger, Representative, why wouldn't we do that?
I'm just trying to get an answer to my question.
Right.
So
and I feel like that is making the law stronger and thus does better for a law-abiding citizen.
I'm just trying to understand what the law is now.
Right.
The law is now that there is no duty to retreat. Is that correct?
Right.
And there is no, there is a right to stand your own ground now, isn't there?
Not where any place that you have a legal right to be. It's not defined. Right now it's defined as habitation.
Right. Do you know of any statute? First of all, do you know of any statute that says that you don't have a right to stand your ground outside your habitation?
We don't have statute that says we do.
I understand that. Do we have any statute that says we don't?
That doesn't matter. I want a law that says we do have the right.
Sorry?
Chairman Bordeaux has the floor.
Thank you. I understand what you're trying to do with the bill. I'm trying to understand how it changes current law. Under current law, is there a statute that says we don't have a right to stand our ground outside our habitation?
The law does not describe that in Georgia.
All right. Is there any appellate decision that says we don't have a right to stand our ground?
Representative, I can't answer that.
Have you come across any?
No, sir.
How does your bill change what the law is and always has been in Georgia?
This bill makes it clear, number one, that wherever a non-habitation, we have a right, a law-abiding citizen, to stand their ground. And number two, we're putting it in code, not case law, but we're putting it in code, that one does not have the duty to retreat, so there's no questions asked.
Other than putting it in black and white, that doesn't change the law, does it?
Makes it stronger.
Thank you.
Vice Chairman Mumford and then Representative Mangum.
Senator Douglas, thank you for bringing this legislation. I just have a question. I thought I was familiar with this, and then when I was reading Section 3, what is the current law regarding civil liability for someone that's injured in a situation of this type?
At this point, if you're protecting yourself and you shoot that person and you take the life of that person, the family of that person can hold you civil.
Can or cannot? Can. All right, so the current law is not that you shall not be held liable. I'm looking down here on line 13.
Shall not be held liable to the person against whom the use of force was justified.
Okay, that's what it says today. Correct?
That's what this.
That's what this bill.
If I'm reading off the wrong.
No, I'm just trying to find out what the change is here, if any. That's where I'm going with this. You're adding. The way I read this, and I could be wrong. The way I read it at line 13, that the current law said shall not be held liable. And you're adding to the person against whom the use of force was justified, or to any person acting as an accomplice or assistant to such a person.
There was a question. We wanted to make it clear that there was questions as to if someone else was harmed. In the old writing, it looked like that you would be held, you'd be protected from that harm also. We wanted to make sure that that was clearly not the case. You were protected from civil liability against defending yourself against that one attacker or his accomplice.
Okay.
So you would not be protected from if you harmed an innocent bystander by some chance.
Okay. That's what you're changing it to.
Right.
But there already was a protection from liability written into the code. That's what I'm trying to find out. You told me there was not before.
Well,
I want to make sure.
Right.
Because what I'm kind of getting here, we're not changing the fact that there was, if I understand the way this is written, and I'm not an expert in this area of the law, but my understanding is that there was already existing an immunity, if you will, in this situation, at least as to persons who were injured, who force was used against appropriately, I guess is the way to say it. Is that correct? Or maybe you just don't know the answer.
I don't know the answer to that.
Okay.
We've made quite a few changes in that section trying to perfect it.
Well, I don't know the answer, and that's why I'm asking. All right. Now, it's your reading of this that if the action, well, I guess it has to be reasonable. Is that correct? If it's deemed unreasonable, then you don't have the protection of the liability.
Correct.
Or the immunity, I guess we should call it. And there's where you shoot and hit some third party who's not an accomplice or an assistant, whatever an assistant is. There's no protection from liability there.
Correct.
So you shoot the bullet, it goes down the street and in the window, hits a third party. They have liability that they can sue and recover.
Correct.
All right, thank you.
Representative Mangum.
Thank you, Senator, for bringing the bill. I think I only heard about it in front of what it does in Congress. I'm just philosophically trying to understand from a policy standpoint. Your first two grounds that you brought, you had 4 grounds, and the third ground that there will be no immunity, and the fourth ground, no civil liability. And as I read it, as Mr. Mumford was saying, you had immunity from liability if you were defending your home before or your personal body when someone used deadly force against you. Is that correct? Is that your understanding?
Under habitation, yes.
Yeah, under habitation. So you were immune if someone was trying to kill me, I got the right to take their life. Or if they're coming into my house, I got a right to, the castle, this is my castle, don't come into my house, you're dead, period. Now I can be on the street like the old Wild Wild West and have my gun, and I can be this big black man walking by, and some pequeño, small, I don't want to say that.
If you need a little white guy.
Because, you see, as a black man in America, I've been in elevators where white women will grasp their pouch and they think I'm going to attack them. Seriously. You don't know what it means to be a black man in America. Seriously. There are people who look at TV and think I'm going to attack them. And some of them have good reason to believe that, on some people. I mean, we got some bad people. That didn't come out like I meant to say. Strike that. My question is this, sir. It appears that now, contrary to the person I really esteem so highly that we were speaking in the third party, who died that nonviolence would be the right, he see democracy means nonviolent resolution of differences. And that's why I was against his other one. I could see we're squashing the dissenting opinion. But right now, as I understand it, if I disagree with you and you feel threatened, you have the right. If it's just you and me, and you say, "Well, he threatened me," so I had to take my long gun out and just shoot him. So now you're really creating an atmosphere whereby we don't try to resolve the differences. And I should tell all these kids in school now, 60% of them not even graduating now because they have no direction, that guy, he bullied you, go home and get your gun and shoot him. Because when I was growing up, it was just a knife. If a knife came to school, we're trying to keep guns out of school now. And I am Incidentally, I grew up in Griffin, Georgia. I'm a proponent of you having the right to have your guns. But my question is, do you foresee, like my colleague over there walking down the street, I won't use, just pretend I'm a white guy, and she feels that I'm threatening her, and she says, she just shoots me, and she says I was feeling threatened. Aren't we going to tie up our court system with factual determinations as to whether or not I was really threatening her, or she secretly had it out for me all along?
Representative, you really believe and you think that would happen? This bill is talking about defending yourself against an attacker. This bill is talking about defending yourself against great bodily harm. We're not talking about solving arguments. Life is going to go on. You're going to have conflict. This is not about solving conflicts. This bill says nothing. It doesn't mention the word gun. This bill is talking about your right and freedom to protect yourself from an attack, to protect yourself from great bodily harm. It doesn't say anything about an argument. So I think that's more of the theory of the FUD factor, the fear, uncertainty, and doubt. The sky is falling. There's no evidence of that happening.
To come back to reality, I guess, in the inner city and in the country, all over the state of Georgia, we have kids now who do not attempt to resolve differences. The only reason someone is in the threat of bodily injury is there is a disagreement over something. And my question to you, sir, is, from a policy standpoint, is it your opinion that we should just get in the position of everyone carrying a gun, and if you feel threatened, just shoot the other guy before they shoot you?
On the first question, I can show you research on the states that have the right to carry. Here again, we're not talking about guns, but if you want to mention it, there are 38 states who have the right to carry. Those states, you can show statistics where crime, murder, robberies have all gone down over the last 10 years in those states. So, but we're not talking about on the other, about settling arguments by shooting one another. You still have the court system. You still have your prosecutors. You still have your juries, your judges.
But when we speak of deadly force, is it not correct that when someone is using deadly force in modern parlance or in modern, the way we use deadly force is to shoot someone, or you could use a knife, but that's kind of out of vogue now. Isn't that correct?
Repeat your question. I don't understand.
When you were growing up, guns were really not in school. Isn't that correct?
Yes.
But now, in settling a dispute, you may have heard of someone getting cut, maybe. But now, deadly force is not a knife. Deadly force now is a gun. Isn't that correct?
Deadly force is anything that takes your life.
Okay. Well, my question is to you. My colleague asked you the question, is there already in the law, isn't there already in the law a right to stand your ground? And I didn't understand why you've added that you could use deadly force here.
It is already in law that in habitation, which means home, personal property, business, that you can use deadly force. This bill expands the territories to any place that you legally have a right to be. So we're expanding. If I am in a parking lot somewhere, and I am minding my business, obeying the law, I should have the right to defend myself without the fear of criminal prosecution or civil liability. I should not have to sit and worry, am I going to be put in prison before I act and defend myself?
I agree with that. so that you understand, I agree with you. My problem is the situation where, I'll give you in the old country way of thinking about it. A man was wrestling with a pig in the mud. And it was very difficult to determine who was the pig and who was the mud because they were both covered in mud. And what I'm suggesting is you are creating an atmosphere where you're going to have two people and it will require someone to determine who was the aggressor, who was the attacker, and you are encouraging people.
Representative, I'm going to have to disagree with you. This is happening every day. The violence happens every day. Crime, robbery, rape. This is not, I don't see where this is going to encourage. I think this sends a message to the bad guys. Hey, you may have somebody here that's going to take up for themselves.
Thank you. I understand that from a public policy standpoint that we are now at the position where we are not looking forward to resolving our differences from a nonviolent standpoint, but rather I have the right to not retreat and meet force with force. That's the way we handle it in the streets. So it's now the Wild Wild West again.
Well, Wild Wild West was back in the movies and cartoons. If you'll read your history books, back in Dodge City, called Legend, Lies, and Cherished Myths, there was no such thing in Dodge City in the heyday of the cattle. 45 deaths a year. So, I mean, this Wild Wild West rhetoric, it just doesn't get it. It's not the Wild Wild West. We want to resolve our differences nonviolently. No question. I don't disagree with you. We want to be nonviolent resolved. But I want the ability, I want my family to have the ability to protect themselves without the fear of criminal prosecution and civil liability. I think everyone should have that freedom.
I'll let you go forward. I just want to say this. This week, there was a young kid who felt that these kids were threatening him. And he said he was going to do what happened out in the in Colorado? Columbine. He was planning to just come back and shoot everybody because he was feeling threatened. And I'm just suggesting that now you're going to give that guy immunity because maybe there are bullies in school, if you've forgotten. There are bullies in school. There are bullies everywhere. There are bullies who use money as a bully. They are political bullies. I'm sorry.
To explain that?
But all I'm suggesting is you are creating an atmosphere where kids are now, is it your intent that that kid can go and there will be a bully in school who will bully that kid and that kid say, hey, I don't have to take this. Tomorrow I'm bringing my gun. That's illegal to do. But if he bullies me today, today is the day. If he bullies me when I walk home today, I'm sorry, he's history.
Well, see, you're wrong there in that. Did he have a legal right to carry a gun? No. So if you look in right here, in the use of deadly force, such person utilizes a weapon, the carrying of possession, which is unlawful. You cannot use that as a defense.
Can he carry a knife?
Is it legal?
Yes. So he can carry a knife.
Can you carry a knife to school? No, you can't carry a knife to school.
Well, let's put it like this then. You can't bring a knife or a school to school, but you hide it under the rock on your way home that you have, or at the bus stop where you know you must go, where they meet you every day. The bullies come and bully you every day. So you keep your knife or gun there. Your knife that's legal. Or I don't know how you have to be. How old do you have to be? How old must I be to carry a gun legally? 18. I'm an 18-year-old slow kid in the 12th grade.
Representative, we're not going to agree.
All right.
We're not going to agree on this.
I appreciate you, sir.
Good answer. Representative Bearden and then Chairman Bordeaux.
Senator Calkin, sorry. You answered one of my questions because I was going to ask you, since when could a 17-year-old carry a gun lawfully? And in the law here or in the bill it says if it's unlawful, you can't use it as a defense. Second question is, how long has Florida had this on the books? About over a year now? Can you give me any examples of Florida turning into the old West and just having shootouts in the streets? Because I don't recall any.
The sky has not fallen on them.
It wasn't not too long ago, crime was running pretty rampant in Kennesaw, and they passed a law for everyone to have a firearm in their home, and crime suddenly dropped. So we're just trying to protect the citizens of this state, law-abiding citizens of this state, correct?
Absolutely.
Thank you for bringing this bill forward.
Chairman Bordeaux.
Does anyone signed up to speak, Mr. Chairman?
We only have one person.
At the appropriate time, I'd like to make a motion, sir.
Hang on, everybody. The members to talk and ask questions. I have Representative Setzler next, then Representative Mumford. I'm sorry. Then Representative Abdul Salam. You're right. She did.
Thank you, Mr. Chairman.
Phil and then Abdul. I keep moving you down. Representative Setzler.
Thank you, Mr. Chairman. To the author of the bill, thank you for bringing this bill. I want to just ask you a question that I think references some of the concerns that I think Representative Mangum was asking. But is it not true that it's pretty well established in case law? And although you are looking to codify case law, you're not trying to codify everything. You're trying to codify what you think you absolutely have to codify, and I appreciate that. But is it not true that in case law, it's pretty well established that any threat doesn't represent the kind of threat to which it would be appropriate to respond with deadly force? That if I were to be in under this bill, if I were to be outside of a department store or to say something aggressive to you and walk towards you, that wouldn't be cause for you to pull out a gun and shoot me. Is that not the case?
That's correct.
That I would actually have to demonstrate a credible threat to your life that would warrant a response of the use of deadly force. Is that not true?
Correct.
And is it not true that's very well established in case law?
Correct.
So I think your concerns that I'm in a department store and someone walks up to my wife and says something rude to her and does something that's ambiguously aggressive, which would then allow me to pull a gun out and shoot him, that's not going to happen because case law is very well established as to the kinds of cases in which I can use deadly force. Now, there is going to be an education component to this where folks need to understand this. That's part of the process of being able to carry a gun is understanding those laws. So I don't think we're opening up the floodgates like you might suggest. I think case law covers most of this.
Okay. Vice Chairman Mumford.
Senator Goggins, I want to draw your attention to lines 13 and 14 on page 2. Again, I'll start reading it. Shall not be held liable to the person against whom the use of force was justified. And then it says, or to any person acting as an accomplice or assistant to such person. Generally in Georgia, I think that the language that's used to describe those people are parties to a crime. And assistant is a term that I'm not real sure about being found in our code. Accomplice is found in our code. Aiding and abetting is found in the code. I can think of a situation, for instance, where someone drives someone to the bank to rob it, and the person goes in with a gun to rob the bank while they wait in the car. I'm a little concerned under this language that you could shoot the person in the bank and then walk out into the parking lot and shoot the accomplice or assistant to the crime. However, I think I have a solution for my problem, and I think it would do exactly what you want to do. If we, at the point where it says shall not be liable to the person, if we inserted the word or persons against whom the use of force was justified, and then struck the language or to any person acting as an accomplice or assistant to such person. In other words, any person who against whom force is justified, person or persons, you could shoot, but you couldn't just go shoot somebody because they happen to be an accomplice or an aider and abettor unless they were involved directly in the violent and tumultuous act.
I think that's what we were getting at.
Okay. Do you see my point, and do you have any real objection to that language change? I think it does meet what you want to do and make it be a little bit sharper. At an appropriate time, I'll make an amendment.
I'll come back and recognize you. Representative Benfield.
Thank Thank you, Mr. Chairman. Senator, my first question is very short, and I've got a second question. That's permissible. And I apologize, you may have already addressed this. What is the position of the law enforcement agencies, the sheriffs and the police, with regard to this bill?
Representative, I have, and the reason I can answer that, and you never know whether it's a true test of accuracy. The Atlanta Journal-Constitution came out against this bill and gave my email address. And as you can imagine, from all over the country, and very few negative emails. Females were for this, believe it or not, on this, and law enforcement. I never got a single one from a law enforcement agency. Not a single law enforcement person has come to me and said one negative thing about this bill.
If I can ask for clarification, though, but has the Georgia Sheriff's Association and the police, what's the police association? The Chief of Police Association, have they come out with an official position?
They have not come to me and said one word at all about this.
And my other question is, I understand Florida, it's correct, there's several states considering similar bills, but Florida's the only state that's actually passed this.
About 22 right now.
And it's been effective in Florida about a year? Okay. I understand that I've read in the news about one case where this has been invoked as self-defense. Are you familiar with that case?
Absolutely.
Okay, my understanding of that case, and I'd like your reaction to it, is there was a private tow truck operator, and he had actually gotten into trouble in the past for taking people's cars, towing people's cars without, unlawfully or questionably whether it was lawful. And he towed a man's car outside a nightclub, took it to a lot that was not owned by him, it was not part of his tow truck lot. The man went to get his car, was driving off with his car, and the tow truck operator shot and killed him. The man was a father of two, described by everyone as a very peaceful man, and did not engage in any type of conflict with this tow truck operator. And the tow truck operator is now invoking this as his defense.
And that is a great example of the state of Florida has said that he cannot use that as a defense because his life was not in danger. And they have made that ruling that he cannot use that as a defense. So that's a great example.
If I may, but he felt authorized by this law that he could act like that, and the man, father of two, is now dead.
Now, how do you know he felt authorized by that law?
He's invoking it as his defense.
Well, anytime one gets in trouble, they use any kind of defense they can get out of trouble.
If I may, my concern
but we can't say he shot that person because he believed that the law, that he knew this law and he was going to do that. You can't say that.
Mr. Chairman, if I may make a brief statement, my concern is that this bill, I don't know specifically what that man thought. Okay, I know he did invoke it as his defense in court.
And it's been overturned.
If I may make a statement, please, briefly. My concern is that this will embolden people to invoke this, whether they were in the right in invoking it or not. In the Florida case, it's certainly an example where it was invoked, at least by this man's attorney, in court wrongfully. And I'm very concerned that this will give people a false sense of assurance that they are within their rights to gun people down. They're not within their rights. And this man, as a court has ruled, was not within his rights under this law.
But within that same context, you would say that the person having the right to carry a gun would, in states where we have a right to carry, that would invoke more gunfights, where we found that we have less crime. We're not going to agree. We're not going to agree either. We're not going to agree either. I'm sorry.
I'll leave that up to you.
We're not going to agree either.
The last person that I saw a hand from was Representative Abdul Salam, and then I think we'll hear from the witness that had signed up to speak.
Thank you, Mr. Chairman. Senator Coggins, you said a couple of times that a person that had a reasonable belief that the person was going to cause them bodily harm, who gets to determine whether it's a reasonable belief?
The juries.
So it's after the fact.
Right.
And in the instance of feeling threatened and feeling that someone may do you bodily harm, there's no specific reference to time frame. I bring to your attention something that's been in the news for the last 2 weeks in Clayton County, where we've had several children missing. We know who had some of these children. The police has not acted on it. They may have others and they may take others. Would the families be justified in taking action in their own hands because they felt reasonably threatened?
See, I don't understand. We're not changing anything. We're not reasonable to believe all this is already in the law. This is already in law. So
what's not in the law is your exemption from prosecution and your exemption from civil.
But do you think a law-abiding citizen should have that?
I happen to agree, and I'm wondering, can these families go get these people? Yes, and their children. To be more specific, their children are. And their children are. But it won't get to court because the police refuse to arrest anybody. So, does this law help these families? Thank you.
Yes.
Thank you.
Thank you.
Okay. Major Stan Savage. Just come on around and you can have a seat there next to Senator Goggins.
Good afternoon. Before I keep my remarks brief, I'd just like to thank the chairman as well as the members of the committee for all your due diligence for the citizens of the state of Georgia. My name is Stan Savage, as the chairman pointed out. I happen to be a major with the Atlanta Police Department, have been for 26 years. However, I'm actually here on behalf of an organization I represent currently now as the president of Georgians for Gun Safety. Some of you may know us. We're an advocacy group for gun safety and education to prevent gun violence, and actually support responsible gun ownership. As a matter of fact, as soon as I go outside, I'm going to be one of those responsible people that have a gun on when I go outside. I feel a little uncomfortable because, like, I guess the earlier bill was about funerals, this was about David the Fourth, and I'm a big black man. Like you said. Some of the concerns that that I have as a member of the organization, as just as a citizen of the state of Georgia, you heard from some of my counterparts earlier on some other bills in terms of things that are associated with training. I mean, just with a traffic stop, and you typically read in the papers, we have to see some chases that may endanger the general public, and so I do have some concerns as it relates to the extension, particularly beyond the home, where law enforcement officers typically see a degree of training and orientation that is obviously greater and above than those individuals who represent the normal citizen. And having been on both ends of a gun, it's a very, very tense. You're sweating, and there's a number of things that actually goes through your mind. And as the representative said from Griffin, just being from our country, you're just scared. You're almost scared out of your wits. So typically, that type of atmosphere, from my experience, has typically breeded an atmosphere of reacting as opposed to reasonably believing. And I just think that there's a big difference as it relates to that. I'm a law-abiding citizen. I've given my life for 26 years to protect the citizens of Atlanta as well as the state of Georgia. My business is locking up bad guys and protecting citizens and actually supporting the Constitution of Georgia and the Constitution of this land of which I took oath for. I do have some concerns. I realize that, and I think you addressed a couple of things that relates to those circumstances that obviously would, obviously circumvent that immunity, but nevertheless a person's life is taken. There was one example given about a person's dog, and I have a beautiful dog that I love very dearly, and in most situations that I've seen, even with gun owners, we read in the paper all the time where a child may accidentally get a gun and injure someone else, and
I'm not so sure that gun ownership equates to responsible gun ownership. And I just know I've had thousands hours of training, and even in circumstances when I've had to make that choice, that millisecond choice of when to pull that trigger. I mean, even with the training, sometimes it's subject to scrutiny, to the media, and rightfully you should be. But I just don't know if a law-abiding citizen, really just kind of, with extending that authority, would have that type of discernment just by having that empowerment to protect themselves. And although you might be able to, go to a court of law, and there might be some circumstances associated with, litigation, and you may be able to, facilitate and get damages. As we say a long time ago, when I used to go through the academy, is that a bullet doesn't have eye. And once you pull that trigger, you can't bring that bullet back. And whatever the circumstances are, those circumstances are just there. So I just want to voice, some of those main concerns. If there's anybody who has any type of questions or whatever, I'd be glad to entertain them. Thank you for the opportunity to let me speak briefly. Thank you for your representation, Senator Goggins, and again, thank you to the chairman and the committee.
Questions for the witness, Representative Randall.
Thank you for coming. Let me ask you this. This bill really makes me feel uneasy, but do you think that this bill would perhaps give a false sense of validation in the event that someone is presented what they perceive as a threat? Do you think this bill can perhaps be, I wouldn't say misinterpreted, but do you think it would maybe give us a false sense of validation? Oh, well, I'll just do it. If I think they're attacking me, I'll just shoot, or I'll just stab, or do you think it perhaps could give a false sense of validation of whatever actions?
As was said earlier, I think it would be hard to say what a person actually thinks. I mean, I can't say what's going through people's minds, but typically, as Senator Goggins says, typically people will grasp at almost anything they can to defend themselves if they brought in a hot seat, and from some of the news articles, from some of the synergy that has been generated around this bill, and again, I'm just going to use my years of experience in terms of dealing with people. That could indeed be a possibility. As you said, right now we don't have just a whole lot of statistical conclusions that the sky's falling in down in Florida and some of the other states. But again, I'm here as a concerned citizen. I love this country. I love this state. And I'm not just a talker. I'm a doer. I've been doing it for almost 3 decades. So again, I'm just concerned. It's not really easy. I know we look at all the police shows, lights, camera action, and the blue lights, and you can name the shows just like a grocery list. But it's very, very unnerving when we see some of the violence and we see some of the cases where individuals have died needlessly. Even here in this state, and I'm not so sure that this bill, particularly in its current state, would not falsely possibly empower, or people have a perception that would empower them, to a greater degree. And most people, I'm going to be very honest. Most individuals, when they buy a gun and register, when they do that legally, I would tend to surmise that most of the individuals typically don't go through a gun class. They don't go through training such as a police officer do when we have to run and do tactical shooting to get your adrenaline flowing, because you have to make that split-second decision. Most of our law-abiding citizens, although law-abiding they be, they typically don't typically undertake that degree of training and sensitivity around gun ownership.
Representative Bearden.
Major, before I get started, let me say I have great respect for what you do, since I did it for 15 years before getting elected to this body. A couple of things I want to point out, because I know where I used to work at, when someone called 911 because someone's in their house, we can't show up at a split-second notice. It took a little bit of time, and I truly believe that this bill allows that individual that competence they need to make sure they can protect their families in their home, and even outside in the car, or if they're going by and see an enforceable felony, they can take action and protect that third party. And I believe that's very, very vital for the citizens to know that, law-abiding citizens. And you spoke about when a bullet leaves a gun, you can't bring it back. I've been on both sides of that pistol too, and you can't bring it back. But you can't bring back a loved one that's been killed by an offender. And if we got a chance here to let them know it's okay to protect themselves, they got to be able to protect themselves, because we can't be there for them all the time. There's no way. And once that bullet leaves the gun, you can't bring it back, but we can't bring back a loved one either. And I hope you understand my position on supporting this, and I do represent or respect everything you do and appreciate the job you've done for so long. So thank you.
Representative Setzler.
Thank you, Mr. Chairman. Again, to the witness, I appreciate you coming out, and I appreciate your service to Atlanta. I work here in downtown, and I think you guys do a great job. What's the current process if you're under current Georgia law? If you're legally licensed to carry a firearm and you're outside of your home, you're just walking down the street, and you feel yourself threatened, possibly with deadly force, what's available to you as a person carrying a gun? What's the criteria you have to go through before you can use the gun in the context of the bill that's proposed?
Well, as initially pointed out, we are fortunate here in Georgia to have, I think, a pretty strong, gun law, currently in this present state. Unfortunately, as it relates to the current law that we have in Georgia, obviously having the license, having the ability to legally carry a gun, you still would have to articulate that threat, against you, and then it would be left up to a court of law in terms of what degree that you, how you interpret that threat. I think it was brought up earlier in terms of trying to facilitate in the court of law circumstances where what that person reasonably believes is mentioned in, I think in the verbiage of this bill, and so it really boils down to how they articulate it. I mean, that's typically what typically happens in a court of law, and as you're probably familiar with in the criminal court of law, you get a defense attorney. A lot of times it depends on how they articulate it. And I think I would like to see, perhaps verbiage that obviously lend itself to perhaps maybe putting some, in laws that maybe put some more sanctions on some of the individuals who are, terrorizing our families and our children, because I think the typical perception in the lawless community of the thieves and the thugs that run our streets is that the laws are too lax, which allows for all the recidivism. And I'm not so sure that carrying a gun or most of the individuals that will have some type of intent on bringing some sort of harm on an individual. Most people are opportunistic. I'm not so sure if they'll think that people may have a gun here, so I'm not going to commit.
It is a little unclear, I think, and that's one of the reasons that the authors bring the bill. Have you ever been in a case where a police officer was in an altercation? Of course, the police officer himself was armed. He or herself was armed, and when presented with a threat, they balked in using their firearm. Have you ever been, whether it's on site or do you know of a case where a police officer was balked?
Well, actually, my first night on the street, I probably would have taken the road that I represented. My first night on the street, I was involved in a gun battle, and my mother thought I was crazy. I stayed with me. Typically, it has to do obviously with a lot of discernment. I know of circumstances where, particularly working in narcotics, where I've been actually shot at. But in particular, when you extend this bill and go to those public places, my returning fire, although I've been trained, I typically shoot expert shooting the high 90s, but that adrenaline and everything is flowing, and so I don't necessarily have a duty to retreat, but we'll typically talk now to take cover, and so you can make some type of decision before you return fire, because if you miss, you may actually take the life of an innocent citizen. And I just don't know that the general citizen would typically have that type of discernment, that type of thinking process in that split second when they have to make a decision between taking someone's life and not in particular when you go outside the confines of the home.
And Mr. Chairman, I'll just wrap up by saying my concern is that whether it's a police officer that's carrying a firearm that maybe due to inexperience or some other conditions balks, and whether or not they should use it, or whether it's a individual in their home who introduces a firearm but doesn't know how to use it, is it not true that those cases typically becomes much more dangerous if you introduce a firearm, aren't equipped or uncertain about using it? That kind of ups the ante and makes it much more dangerous. My concern is without the clarity this bill provides, and I say this to members of the committee, on someone's ability to use that if they're threatened with deadly force, the idea of folks who are armed walking around in our communities that don't have clarity in the fact that if they're approached and if they're attacked with deadly force, that they can use it. That uncertainty, the confusion there might heighten the danger and further endanger them. I think the clarity this bill provides, is it not true, could provide the clarity that could frankly save a life.
Well, one of the things that, and you mentioned earlier, I think about education. I just don't know what type of intentions might be surrounding the education of the citizens, so they can, obviously understand that. I mean, most people be looking around for July the 1st, and then, it would be interesting to see the number of guns that are bought in Georgia, perhaps maybe if this law was passed, and what type of circumstances may come from it. But I know it's all a lot toward to speculation, and again, I just basically wanted to this body to hear my concerns, and again, I thank everybody for their patience and their attention.
Chairman Franklin.
Thank you, Mr. Chairman. I'd like to address this question to Senator Guy. Isn't it true that, aren't there statistics that show that homes that have security systems with signs, those are least likely to be broken into? Don't the criminals choose a safer place to do their business?
Absolutely.
And would the Major agree with that? And isn't it true that when I think it was already alluded to that in Kennesaw, when they passed their law requiring everyone to have a firearm, that the burglaries and the home invasions came to a screeching halt because the criminals realized that might not be the best place or the safest place for them to conduct their business. Yep. And isn't it true that if we pass your bill today unamended, that it will be sending that same type of message to the criminals out there, that if they're going to assault the good people of Georgia, that it might not be the safest place to do it, and they might want to go to some other state that hadn't enacted something like this?
Thank you.
All right, let me ask you one other thing to address what Vice Chairman Mumford had brought up, and that's the last two lines of Section 3, where it talks about, or any person acting as an accomplice or assistant to such person in any civil action brought, and then this is I think the kicker here, as a result of the threat or use of such force. So doesn't that pretty much tell us that the assistant or accomplice has to be using that force, and therefore we don't need to amend this bill?
I would agree with you.
So I think that's fairly clear that the assistant isn't just someone sitting out in the car outside, but has also used force or threat of force. Isn't that correct? All right, thank you.
Further questions, members of the committee? Further questions, Representative Everson.
a general question to either one of the gentlemen here or to anyone on the panel here. Is there any information available? We've spoken a lot about Kennesaw and when they implemented their city ordinance as far as allowing citizens to have a gun. And piggyback on what Representative Suchler said, as far as the educational component of this bill, is there any information available to address whether or not the city of Kennesaw had an educational component when they implemented their city ordinance?
Mr. Chairman, I'll probably get you an answer to that.
Representative Setzler will take you on a field trip up there as soon as we have time. Briefly, Chairman Franklin.
One thing, there was a, back in the, I think the early to mid 90s, there was a senator that introduced a statewide Kennesaw ordinance, and there was a hearing in the Senate, and I actually attended that. And someone asked the mayor and the chief of police of Kennesaw, now that you've got 10 years of track record of this law, how many accidental shootings, how many crimes of passion have there been? And the answer was 0 in 10 years.
Further questions from the committee? Further questions? What's the pleasure of the committee?
I'll make a motion do pass, although I want to be heard for my amendment.
Okay, let's take up your amendment first.
Senator Goggins, I want to restate again, with all deference to my good friend Mr. Franklin, I believe that the clause there where it's referring to any civil action brought as a result of the threat or use of such force really is referring to the civil action itself, whereas what I'm trying to do is show that the person who is eligible for having deadly force used against him must be embroiled in the use of deadly force. So I don't know whether you still want to accept my amendment or not. That's the spirit of the amendment. I do not think that the amendment dilutes your intent in any way, and I do not think that the using the word assistant or person acting as accomplice or assistant is really consistent with our general use in the code. I guess I could ask legal counsel whether I'm right about that or not. I am correct. All right. So I guess I'd pose to the author, do you consent to my amendment, or do I need to move it?
I would prefer to leave it as is.
All right.
Thank you.
Then I would move my amendment, which would be that at the line after the word to the person, on line 13, I would insert the words or persons being plural, and then after the word justified, I would strike from or to any person acting as an accomplice or assistant to such person, and after that, then it would end at person. So it would read, shall not be liable to the persons or persons against whom the use of force was justified in any civil action brought as a result of the threat or use of such force. And I do make that motion.
Is there a second? We have a motion to amend Senate Bill 396. First of all, does everyone understand the amendment? Any clarification needed? Is there objection to the amendment? Representative Bearden.
I misunderstood you. You just said you like to keep the bill as is.
As is.
We have an objection. Is there discussion now on the Mumford amendment? Chairman Bordeaux.
Thank you, Mr. Chairman. Mr. Mumford, isn't all you're doing is keeping the spirit of what this provision provides, but putting it in language consistent with other provisions of general Georgia law?
That is exactly, Mr. Bordeaux, what I am trying to do. I am not trying to take away any of the, I don't know how to describe it, the meat of the bill. I think that what I'm doing leaves it exactly as it is, but as I said, I'm pretty familiar with the code regarding parties to a crime and assistants and accomplices. and there is no place in the Georgia Code that I'm aware that the word assistant shows up. And I think that just is, it's a broad word, accomplice and assistant. You can have accomplices that are miles away from a violent offense, and obviously nobody here contemplates that they would be subject to legal execution. So I would just ask that that's the purpose of the amendment.
Is there any, if I may, Mr. Chairman, is there any reason why you want to use terms that we use throughout the code as opposed to inventing new terms?
They're generally accepted, and lawyers understand what they mean. That's the problem with the word assistant. It's not. It's a weasel word. It's broad.
Further discussion on the Mumford Amendment. Hearing none, the chair calls the question. We're first going to vote to see if we're going to amend it under the Mumford Amendment. Any further discussion? Hearing none. All in favor of the Mumford Amendment, please indicate by raising your right hand. All opposed? Tie. Okay, I vote no. Any further discussion? Any further amendments? What's the pleasure of Chairman Bordeaux?
We're discussing the motion to pass.
Yep.
A point of clarification in terms of this bill came through a committee I'm privileged to sit on, chaired by Chairman Knox. I voted against the bill in subcommittee. I'll vote against it again today, but for a different reason. When I voted against it in subcommittee, I thought that it did what is commonly said in the press that it does in terms of returning it to the Wild West, etc. It doesn't do that. It doesn't do anything. This is what the law of Georgia is already in every substantive part of it in terms of this business about duty to retreat and right to stand. That's the law already. We're not advancing the law one iota. It may be good political fodder for some folks, but it doesn't change the law. I'm going to vote against it, though, today, not because of substantively what it does in terms of changing the law, because it doesn't change the law. I'm going to vote against it for the reasons that Ms. Stuckey-Benenfeld set out, that because of how it's going to be reported in the paper, somebody's going to think that next time somebody bullies them at school, they can wait for them with a gun outside the school zone and gun them down if they're over 18, age 18 or over. And if I just don't want their blood on my hands. It doesn't change the law substantively, but I think how it's going to be reported in the press is going to cause something I don't want to have a part in. Thank you.
Further discussion on the motion. Representative Mangum.
I just need clarification. My distinguished legal professor just said that it didn't change the law, but I'm just asking a question of the author or the chair or Mr. Bordeaux. On line 18 of the bill, on the first page, it clearly says a person who uses threats or force, and it lists 3 provisions. And as I understand it, and if you're telling me it's already existing law, but it has the words including deadly force. Is this a new provision or is this existing law? Is this a new provision that we are now adding to the code 16? Right. This code section doesn't. I know I went to law school, and unfortunately they allowed me to study and read. And I have never heard of someone threatening you and then you are justified to use deadly force. It doesn't say what type of threat. It doesn't say threat with deadly force. I can say boo, and that's a threat. It could be interpreted as a threat. But are you saying that 16.324, if you have a copy of that provision, sir?
I was going to let him finish. I'm not sure.
Well,
we don't have that long.
Thank you, sir.
Mayor.
Are you finished?
I'm finished.
Okay. Chairman Bordeaux.
Thank you, Mr. Chairman. To the gentleman, I think the key to what you're asking, but I think you're right to the point, but the key here is on page 1, line 18, where it says, as provided in said code sections. If you go back and look at those particular code sections, as I have, it restricts it. It's not just a blanket, Wild West, gun them down, shoot somebody who makes you mad. The key is as provided in said code sections, and those code sections provide the qualifiers that you're looking for.
Further discussion. We have a motion on the floor to give Senate Bill 396 a due pass recommendation. We're now in discussion of that motion. Is there further discussion? Is there further discussion? Hearing none. Thank you. Hearing none, we'll call the question. All in favor of giving Senate Bill 396 a due pass recommendation, please indicate by raising your right hand. All opposed? The motion's adopted. Thank you, Senator Goggins.
Mr. Chairman.
Thank you.
Committee. I appreciate it.
Yes.
I intend to file a minority report on this bill.
Hang on one second.
To close the business day. I think
Tell
the
me.
rules are we're supposed to file on the close of the business day. Is that correct? So
I think so.
Some guidance on when this would have to be filed in a minority.
I will support whatever need be to be sure that you get to file one. I don't know what's the proper way to do that.
I don't even know if anyone's in the clerk's office to accept it.
Excuse me, next foot. Yeah.
Okay. So if
Do you want to
file by 5 o'clock tomorrow, then
Yeah. Do you want to? I was thinking about a stretch our legs break. Do you want to check with Robbie and be sure?
I think you need to file it at the same time as the committee.
I was going to say, do you want to put it in the bill in the morning? We'll file it with the bill.
That's what I.
Oh, that's what.
And what time is that filed? By 10 o'clock.
Yeah, we'll put it in by 10 if we can do it.
And I'll check with Robbie.
Does everybody want a short break before we start the next one?
Yes.
Well, immigration. We're going to be at ease for about 5 minutes, and then we'll take up Senate Bill 5. Okay, we have one bill left on the agenda today, and we intend to get through that bill. And let me sort of tell you where we are on, we're talking about Senate Bill 529. We have a new version of that, and Senator Rogers will be presenting that shortly. This bill was heard extensively over 2 days by the Mumford Subcommittee, and as my understanding, basically that subcommittee has referred it on to the full committee without a recommendation, and actually were unable to hear all of the witnesses that had signed up, and so we are going to hear those witnesses to begin with. I would encourage you, and I don't want to limit anyone. I think you see that we let people have their say, but I would encourage those who testify to be concise. So with that, we have still 7 people who had signed up this morning on Senate Bill 529, and those that are here, we will recognize them, after which time I will recognize Senator Rogers to walk us through, and I'm very pleased, and I think he will go into this further when we get to that point. He and Commissioner Thurman have had some lengthy discussions since the subcommittee, and as my understanding have reached agreement on some very, very important parts of this legislation, and I want to commend you for that. And the commissioner, I don't know, I saw him wander in many hours ago when we started. I see some of his staff here, but
leave and go to Athens to a meeting.
okay. But the department will have someone here to chime in. Is that right? Okay. All right. We could have a little order, please. We'll first recognize, and I don't have a first name, Dr. Painter.
Right here.
Come around, please, ma'am.
Okay. I'm Dr. Levon Painter. I am a pediatrician, and I just retired a few months ago, and I spent 35 years working in public health. So I have an intimate knowledge of the impact that undocumented immigrants have on our healthcare system. I don't know if you're all aware of it, but the federal government mandates that local public health services be provided in many health areas for anybody, any child. I'm talking now about children, any child in this country. And we don't even have a right to ask whether they're documented or not. We are supposed to establish a means test to make sure that they are eligible for services. But in many cases, we can't do that with undocumented because we ask them for check stubs. They say they don't have any. We ask them for some kind of income. They say they don't have any. And on it goes. But in addition to all the well baby clinic procedures that we do and immunizations, we have to screen kids for lead poisoning. We have to screen them for tuberculosis and many other things. And many of these children, these undocumented children, do have positive screenings. And then we have to follow up on those, whether they have any income or not. We have to somehow provide for them. In addition, they're eligible for children's medical services, and children's medical services, as probably most of you know, provide long-term care for children with chronic problems, with asthma, with seizures, with diabetes, spinal bifida, so on and so forth. And the CMS program has just been inundated with children who are here with undocumented workers. In addition, they get benefits from the WIC program, which is the supplemental food program that lasts for the first 5 years of their lives. They're eligible for early intervention, which means that if they have some developmental delay, we can put them in WIC programs, and again, the federal and state government pay for this. In addition to those services, pregnant women, of course, are eligible for temporary Medicaid, even undocumented. They're eligible, so they have prenatal care, postnatal care. And in general, I would say that the fertility rate in undocumented women coming from third world countries is much higher than the fertility rate in women living in this country. So it becomes a very expensive undocumented people are very expensive to maintain. Their labor is cheap, but the cost of the taxpayers is very high. Now, in terms of health care, SB 529, which I favor, is not going to change any of this. We're still going to have to carry out all of these health programs. But what I'm hoping it will do is to discourage undocumented workers from coming to Georgia so that we don't have that terrific expense to all of our taxpayers. And there's a lot more, but I'm going to let it go at that because it's getting late, and if you have any questions, I can answer them.
Where did you practice prior to retirement?
I was with the Fulton County Health Department. I was the director of child health.
Questions from the committee to this witness? Questions from the committee. Thank you very much,
Okay.
Dr. Painter. Maria, is it Litland? Did I get that right? Yes. Okay.
Good afternoon. Maybe already good evening, ladies and gentlemen. Yeah. Thank you for the opportunity to speak to you today. I'm here to urge you to vote for SB 529. Allow me to tell you why this is so important to our fellow Georgians, Americans, and legal immigrants that this bill becomes law. I am an immigrant. I'm a lawful, permanent, legal resident of the United States with a green card, who followed the law to earn this gift. I followed the rule to enter this country. It was not easy to earn the privilege to live legally in the United States of America. I had to show proof that I had no criminal record in my home country or any diseases. This documentation had to be translated into English and certified that it was correct. It is a slap in the face to every legal immigrant who followed the process to earn legal residency to have any elected official allow illegal foreigners to remain in this country. Illegal aliens are not immigrants. They don't pay taxes. I came here according to the law. I demand equal protection under the law. I'm upset that every day or night I see illegal aliens enter our country without records of who they are or where they come from. Nobody knows if they are hardened criminals, have any diseases, or even worse, they could be terrorists who could murder your family and mine. I'm angry that illegal aliens have more rights than Americans. I cannot go to the hospital and get free medical care like illegal aliens can. 34 million Americans do not have medical insurance and are expected to pay for medical services, and illegal aliens are not. This cost Georgians $88 million in 2004. How can you give criminals free services and deny the same to Americans? There are federal laws that make it illegal to hire illegal aliens and fine employers who do. I don't want to see illegal aliens hanging around street corners and gas stations, taking away work from citizens and legal immigrants. I also don't want to see police cars standing right next to illegals without enforcing the laws. Also, I'm sick and tired of seeing Americans being put out of work because unscrupulous companies hire illegal aliens. They are criminals. I am appalled and disgusted that our elected officials continue to let this happen. It is your job to enforce the laws of our land. Why you have neglected to do so? Please think about your friends, your family, most important, the future of your children and grandchildren, about the impact illegal aliens living in our states have on them now and in the future if you allow our state to be a magnet for illegals to come to. Show the 80% of your constituents that want something done about illegal aliens, that you are listening to them and not special interest groups. Georgia and the country depends on it. Thank you for listening.
Thank you very much. Questions of the witness? Questions? Representative Setzler.
Thank you for coming and testifying today. What is your nation of origin?
Austria.
Austria. As a former Austrian citizen, how long did it take you to gain citizenship in the United States? And could you very briefly describe some of the process?
Oh, it took me at least 8 months.
Okay.
I always came with a visa, and I had to go back and forth.
Were you just coming over to work? Were you married to an American when you came over to get your citizenship?
No.
Okay.
But I got married later.
Okay. Thank you.
Further questions? Thank you very much.
Okay, thank you.
Reverend Wendell Phillips. Reverend Wendell Phillips. Steve Skinner. Steve Skinner. Francis Mulcahy.
Mr. Chairman, members of the committee, my name is Frank Mulcahy. I am the Executive Director of the Georgia Catholic Conference. I represent the Catholic bishops of Georgia. I hope that all of you have had the opportunity to read the statement which the bishops prepared and have circulated throughout the country, actually. And I'm not going to try to repeat that. I will certainly adopt everything that they said, and I probably couldn't say anything any better. What I would like to do this afternoon is just point to a couple of things, in some cases a response to some of the statements that were made this morning at the subcommittee meeting. The bottom line for the bishops is that they support the federal report. They support solving the problems of immigration through the federal government. Now, we can all sit here and say the federal government didn't do the job, they haven't done the job, and they may not do the job. They're going to pass a bill, but I don't know what it's going to do. Nonetheless, it is by and large a federal issue. And the concern we have overall with the bill is that it puts burdens on the state and on citizens that don't really seem to be proportionate to what those things will accomplish. A couple of points from this morning. There was discussion of the business use of undocumented immigrants, undocumented aliens in a number of different businesses. We do well, and the comparison was made to the third world countries, where there are groups which object to some of the people who are paid 10 cents an hour or something like that. In effect, we've already done something like that and accepted that in the United States. In that, a lot of the undocumented immigrants are not getting the fair treatment that they deserve. It would be our position, which is beyond the scope of this bill, I realize, but that we would advocate for the benefits that they are entitled to by law, some way for them to get it and be given a living wage. Our concern with this bill is that it will drive some of them further into the shadows and further able to be exploited. Another area which doesn't seem to solve a problem, but certainly creates a lot more bureaucracy, and that's in Section 8 of the bill. It has to do with requiring affidavits. And these affidavits for the receipt of benefits need to be provided by everyone who are applying for the benefits. Our concern there is with a lot of the people who are seeking welfare benefits and don't have access to a notary public to prepare an affidavit. It doesn't seem to make any difference whether someone has been receiving benefits for a period of time. And the concern is that a lot of these people will get lost through the cracks because they can't get an affidavit, they can't get a notary public, and maybe some of them don't even know what a notary public is. But to lose these people who are entitled to benefits seems unfair. Mr. Chairman, I could let me just finish by saying that on the overall national basis, the bishops in their principles for immigration law specifically say that they recognize the right of any government to protect its borders. They furthermore respect the rights of the legislature, the Congress, to pass laws and to expect people to obey them. Their concern in this is for the people who have been here for whatever reason, not to just disregard them. Now, we can blame the federal government, we can blame anybody we want, but the fact is we have a lot of human beings here, and we need a solution. I realize that asking or hoping the federal government will come up with a solution may not be a wish that's fulfilled, but for the reasons I've stated, I don't think most of the provisions of this bill will do that. Except I will say things about sections 3 and 4 of the bill, which have to do with human trafficking, which goes beyond immigration, but we certainly support a bill which will criminalize human trafficking. In addition, I believe it's section 6 of the bill proposes to regulate the notarios, some of the people who are preying on illegal immigrants, giving them documents. I've heard in some cases where they give them documents telling them they're a citizen and charge them $5,000 or some amount of money, but the papers are bogus. So we do support that provision to regulate these people and get them to be fair. Mr. Chairman, I appreciate the opportunity to speak. I'll be happy to answer any questions.
Any questions for the witness? Any questions for the witness? Thank you very much.
Okay. Thank you, Mr. Chairman.
Janice, is it Barocas?
She has to leave, Mr. Chairman.
Okay. Brian Matthews.
My turn came up more quickly than expected. I'm a native Atlantan. There are not that many of us left, but I am. I've grown up and watched the city change. Change is good. I've got a college degree in actuarial science and computer information systems, but I also work in the blue-collar industries of plumbing, heating, and air and landscaping. I've watched those industries change tremendously over the last 15 to 20 years. 20 years ago, I could pay a guy $2 an hour, and no questions asked. He would pretty much do whatever I asked. Today, those same workers are requiring $10, $12, $15, $18 an hour cash. I'm not sure about some of the people that are being taken advantage of in South Georgia, perhaps in the agricultural industry. But I'm here to tell you, in the past year and a half, have throttled back a 11-vehicle landscape fleet to 0 because the compliance of trying to keep these people who are here illegally to give me valid Social Security numbers that are going to let me off the hook. We've tried everything we can to document them and have had actually people come up and offer to change their Social Security number. The one they gave us didn't work. You've got to look at things besides the businesses, the big businesses. You've got homeowners that employ maids and landscape people. I'm not upset that I lost the business. I'm upset that the cost overall to this system isn't being analyzed. People think they're getting them for the cheap, but when we look at the long-term issues, the things that we've talked about, health care and social services, you can't put a dollar value on it. And trust me, I'm an actuary. If anybody can do that kind of thing, it should be myself. It's very frustrating. And I had a builder this morning before I came down. And by the way, I never do this kind of thing. This is totally just spur of the moment to me. I said, if I don't do something, I'm part of the problem. For a few years, I was part of the problem. If I don't do something now to try to remedy that, I continue to be part of the problem. I talked to a builder next door, building a house next door to me today, and I said, we've got to address this issue. You've got to quit just going and picking up illegal day labor that you know is illegal. By the way, there's a form called an I-9 that has criteria you're supposed to check, and he just laughed at me. Ladies and gentlemen, I had to show an ID, Georgia driver's license, to get in this building today. It's absurd to me that someone can just work on the public dole
and not. Anyway, he sits there and tells me, well, that'll drive up the price of housing. You won't be able to afford a house anymore. Well, he didn't go to college. He doesn't understand basic supply and demand, but obviously if all these workers are here also, they're causing the supply of housing to go up. So they're causing part of the price escalation that we're seeing in addition to other things. The traffic, the congestion, the number of cars you see with tags that you know aren't valid, the vans and trucks I see now that say licensed and insured. And in the last week, I've actually jotted down numbers, gone and researched it, gone to the Secretary of State to see if those businesses were indeed valid businesses, taken the county of the tag, called the county, seen if there was a valid business license, and 19 out of 21 times, I've not been able to find any evidence to show that these businesses were indeed licensed and insured. Check cashing. You've got a whole system of people who don't use bank accounts, use check cashing stores. I know because I've had to go in and vouch for them in the past. Yes, this is Juan. Yes, this is Jose. Please cash his check. And for a 2 to 3% percentage off the face, they walk out of there. So a $100 paycheck, $2, $3, I get $97.98. I pay no Georgia tax. I pay no Social Security, no Medicare, no federal tax. And this is going on left and right. I myself could go in there with a check made out to just about anybody and cash it because they know my face. And if I don't, I know somebody else who can. I'm just frustrated, and I think these issues need to be addressed. And I think it was put eloquently earlier that we're not trying to deny anyone benefits. We're just trying to make sure that they're actually entitled to the benefits. I make better than 6 digits a year, and, I'm not entitled to certain types of public assistance. I'm not being denied it. I'm just not entitled to it. So I ask that y'all review this. I don't think this bill does it all. But if we don't take some step and we say, actually, I was a little offended this morning that y'all were all being told it's a federal matter and there's not really a whole lot y'all can do about it. I want you to do something about it. I've lived here all my life, and I want y'all to do something about it. It's happening in our neighborhoods. The federal government is welcome to do what they want to do. I think it's crazy to just roll over and say, let it come down from above. So I encourage you and I ask you to do something about it. I think this bill is a step in the right direction. It certainly doesn't address it all, and I'm always available for comment or help or input, and I know it's late, so.
Thank you very much, Mr. Matthews. Questions from the committee from Mr. Matthews? We appreciate your first appearance before a legislative panel being before our committee.
No, I appreciate it. Thank you.
Maybe you'll come back and see us again sometime.
I sure will.
Okay. Recognize Senator Rogers.
Thank you, Mr. Chairman, members of the committee. I figured all those media people were here for me, but I guess I was wrong. They went home.
Don't be greedy.
I don't want any more, believe me. And after I show you something here in a minute, you'll know why. I think you heard the testimony from a lot of people today, and a lot of it dealt beyond what the law says, but really dealt with the emotional impact of where we are with this issue. And I just want to clarify a few things and go through the bill quickly and answer any questions, but I want to do it justice because of the importance of the legislation, but recognizing also the hour that we discussed this. I began this personally 4 years ago when I was elected to the House, and we began the process of introducing legislation dealing with this. And ultimately what we decided this year was to put these many ideas into one bill because we didn't want to have immigration bill after immigration bill after immigration bill. Figured we'd put them into one bill, and that's why we have Senate Bill 529, and that's why I characterize it as a comprehensive piece of legislation dealing with this particular issue. I'm going to go through this quickly, but these are just some of the people I've worked with since we started this. Georgia Sheriff's Association, the Department of Revenue, Department of Agriculture, Commissioner of Labor, Immigration and Customs Enforcement, Chamber of Commerce, insurance industry, Georgia Hospital Association, prosecutors, defense attorneys, builders, contractors, manufacturers, people on my side, people against me, law enforcement, hospitality industry, healthcare officials, women's groups, my constituents, and many of your constituents. I've actually traveled this entire state giving speeches on this issue. And I will tell you that it doesn't matter if I was down in Waycross like I was a few months ago, or in Norcross like I was a few months ago, or up in Blue Ridge, or anywhere I've gone, this issue, everybody wants something done about it. I don't think there's any question about that. So what do? Well, we look at it and we say, well, as the gentleman who just spoke earlier, do we consider this simply a federal issue? Or is there something the state can do? Because I really think that's the crux of the matter. Because we've heard time and time again today, well, we don't need to do anything about this. This is simply a federal issue. But immigration law is really two parts. The first part is enforcing our border. That, up until this past month, has always been held to be a federal issue. And I'll talk a minute about why that has become a state issue. The second part of illegal immigration and immigration law pertains to what the state and local governments can do. And that would be what we would characterize as interior enforcement. And there are programs that the federal government has given us as tools to help us address this situation. And clearly, if the federal government had not intended for the state and local governments to be involved, they would never have given us the tools. They would have not defined it in federal law, and I'll talk about that in just a moment. But if you want to highlight why the state of Georgia ought to address this today and not 10 years from now, simply look out west at what has happened in New Mexico and Arizona and realize, yes, in fact, the governors there did declare a state of emergency. And no, it wasn't only because they wanted some money. They declared a state of emergency because it was a state of emergency. Beyond that, and this deals with the state government dealing with this issue, just this past month in Arizona, they have now called out the National Guard to begin defending the border. I mean, this is how far they're willing to go because of the importance of this issue to their citizens. So I think it's important the state of Georgia look at, well, what's happening elsewhere. Is that potentially going to happen in Georgia, and what can we do to address it? So that's what Senate Bill 529 does. It addresses it. I've handed you a packet, which we also gave out in the subcommittee, but many of you weren't on that subcommittee, and this would be the front page of it. And it deals with the three areas that the federal government has, three tools, I should say, the federal government has given us to deal with this specific issue. Those three tools are the SAVE program, which is the Systematic Alien Verification of Entitlements, the Basic Pilot program, which is a part of the SAVE program, and it is used for employers, and the third part is the Law Enforcement Support Center. Now, there are other tools that go beyond this, but these are the three that are highlighted in this particular legislation. And as I go through the bill here, we'll talk about where those tools play into this bill. If you'll, the copy I'm going to be working from is LC 185607S.
Now, just for the benefit of those that were on the subcommittee, this is a different version than what we had before us this morning.
Yes, sir, it is.
And yesterday.
Thank you, Mr. Chairman. It is. It's LC 185607S, as in Sam.
This hasn't been passed out of the subcommittee.
The subcommittee passed it on without a recommendation.
This is what was passed out of the subcommittee with no recommendation.
No, this is. We, Chairman Mumford and I, Commissioner Thurman from the Labor Department was there. He and Senator Rogers wanted an opportunity to work on reaching some agreement on some issues that I thought was important to do. Their agreement is incorporated into that.
I guess, probably to be more accurate, I guess what you could say was came out of the committee without any recommendation would have been LC 1855-99S. I guess what the proponent of the bill is now offering is essentially a substitute for that under this new number.
Do we have it?
It is. And I don't know what else the author's going to tell us about, but the major changes are in section Article 3, Section 2.
I will go through this quickly section by section. In your packet, you'll find where we've broken it down section by section, but I will tell you that is old because the sections have changed, but much of the information is still good. Section number 2 is the new section. Of course, Section 1 is simply the title. Section 2 is the new section that is the result of the work I did this morning with the Commissioner of Labor. And I know that some of his people are here, and this is exactly what we took to Legislative Council, so certainly they can testify to that. but we came to an agreement on this. And if you were part of the subcommittee, you know we discussed the basic pilot program and the implementation of that statewide, as well as a program that the Commissioner of Labor wanted to implement that allowed him to begin doing, for lack of a better term, spot checks on employers throughout the state, and giving him the authority to do so. What we ultimately came up with was a plan that in fact did both of those, but we did so in a manner that would ease us into it over a 3-year period. And the way we ease into it is through the number of employees, and I'll touch on that. The beginning on line number 22, it talks about no department or agency, basically any government in the state of Georgia, or that they all will have to take part in the basic pilot program. And just quickly, because I think this is very important. There was a lot of discussion this morning on what the basic pilot program is. It is a free system offered by the federal government to verify your newly hired persons. It cannot be used for screening purposes. You cannot take an applicant and run them through the basic pilot program to see if they're legal. You have to hire them first. Then you have 3 days to determine, or to use the system to determine whether they're legal or not. If the initial information comes back, and it has about a 97-98% accuracy rate, but if you're part of that 2 or 3% and it comes back and says that you're not allowed to work and you really are, you can file a secondary verification, at which time the secondary verification is estimated to be 100%. That would be completely accurate because they physically pull the file to make sure that there's no problem. I spoke with SAVE program this morning. Last year, nationwide, there were about 125,000 people where the initial response came back no. Of those people, only 4,000 ultimately were found to be not eligible to work. So as you can see, a majority of them actually were able to work. But anyway, with the basic pilot program, what I found interesting was you can call a basic pilot program today in Washington, D.C. and say, send me a list of all the Georgia employers that are part of this program, and they'll send it to you. I did that on February 13th, and this is what they sent me back, and it's a list of all of them. In your packet, you will see a list of some of the main ones, and it says, who uses basic pilot in Georgia? And when I first read this, I was a little shocked, to be honest with you, because usually the idea is that poultry industry, carpet industry, they can't survive without the illegal labor, so they would never use a program like this. But in reality, just to read you a couple of the names, Gold Kist, Hormel, Purdue, Pilgrim's Pride, Sanderson Farms, Tyson Foods, they all use it already. And the same thing for hospitality, construction, and many governments, City of Columbus, City of Jonesboro, City of Kennesaw, City of Noonan, they already use it. So we felt, well, it's free, it works, why don't we just have at least state employees or government employees throughout the state be subjected to this to make sure that they're legal. And the Commissioner of Labor agreed with me, so that's what we have. And that's lines 22 through 25 on page 2. Lines 26 through 30 would require that anyone working on a public contract also register and use the basic pilot program. In other words, so what we're essentially saying is surely governments in Georgia should follow the law as it pertains to hiring persons legally, and surely those persons who are working with taxpayer dollars ought to follow the law. The change you will see begins on line 31, and it sets forth dates over a 3-year period in which we will phase into this. The first phase will be employers of 500 or more. The second phase would be employers of 100 or more. And then the third phase would be all employers. And again, these are all employers that are working on public contracts, not all employers across the state.
Chairman Bordeaux. What's the preference of the committee? I'd rather do it by section. Does the committee prefer to do that? Okay.
I'm prepared any time to.
Are you finished with section 2?
Well, the second part of section 2 is what's known in here as Article 4, and that's the part the commissioner added, and I would want to get to that.
So you want to stop and address Article 3 as he's explained it up to this point?
No, I was just going to suggest that we basically take it code section by code section rather than full section of the bill.
Okay.
Representative
Setzler.
Thank you, Mr. Chairman. Senator Rogers, again, I appreciate you bringing this bill, and I've heard from constituents who've contacted you and folks from all over the state. I laud you for your approach. Does the language included on page 2, lines 26 through 30, maybe this would be better addressed to Legislative Council, but does that language require a subcontractor working directly for a prime contractor and any subsequent tiered subcontractor to comply, as we discussed?
I believe it does, and
okay.
In Legislative Council, the Legislative Council I work with confirmed that it does to me.
Okay.
Simply because we talk about no contractor or subcontractor who enters a contract subject to this article, and the subject of the article would be that it's a public contract.
Okay.
Okay. I think where we are, you had finished Article 3 and up on page 3. Is that correct?
Yes, sir.
All right. So let's go back. Is it okay if we start with Code Section 131090?
Yes, sir. I have no questions with regard to that.
Okay. Any questions? Any questions about? Let's do it this way. Any questions about page 2 before we start doing it by code section? Chairman Ward.
Thank you. And this is following up on what Representative Setzler. On line 20, page 2, line 26, where you talk about a contract subject to this article, and we may need to direct this to Legislative Council. What contract is subject to this article?
The contracts that would be entered into by the department, an agency, or instrumentality of the state, or a political subdivision of the state. Mr.
Chairman, may I direct to legal counsel?
Sure.
Legislative Council, whether she thinks
she doesn't have to answer you or anyone else.
I found out no one has to answer me.
I would have to admit that I'm confused as well. I don't see where it talks about contract subject to this article, but it's the beginning of the Federal Work Authorization Program. And then on line 32 we talk about employers, but then employers aren't defined, but I'm assuming it's supposed to be one and two. So I have to admit that I'm a little confused as well.
You want to be heard?
No, I'm.
Oh, okay.
I'm waiting on the question.
Well, the question is this. I don't think, and frankly, I don't think I've got any problem with your subsection, this code section 131091, and I think it's a good idea, matter of fact, but I don't think that your language simply saying contract subject to this article is clear as to what contract is subject to this article. B1 talks about an instrumentality of the state, but then you talk about on line 26, contractor or subcontractor who enters into a contract. I think you need to clarify that it's limited to contracts, or you're referring to contracts with the department, agency, or instrumentality of the state or political subdivision. Secondly, and following up on what Ms. Travis said, on line 32, suddenly you're talking about employers or employees. Well, if you're a subcontractor is not an employee of a contractor by definition. So you're mixing apples and oranges, I think.
Well, but the subcontractor would be an employee.
That's the point. They're not. Unless I.
But as a business, it would be. It could be an individual subcontractor, or it could be a business subcontractor. If I'm a contractor, I can subcontract to another business. I can also subcontract to an individual.
Sure, but if you're my subcontractor, you're not my employee, and I'm not your employer. So,
right, but what the section refers to is that the contractor or the subcontractor who would be affected by this section above it those companies with 500 or more employees would be affected by that particular date, and then 100 employees by the next date, and everybody by the third date.
I'm just honestly confused by the language.
I understand.
Representative Setzler.
And again, I just want to, I'll share a circumstance very quickly. And if you've got I want to make sure that the further you go down the ladder, or as we go down the ladder of these contracts, that it's crystal clear that if for example, you've got a small firm that's meeting a small business goal or a minority participation business goal that's the prime contractor for construction contract. They serve as the program manager with a large general contractor under them. As a first-tier subcontractor, they get a site contractor to do the site work, and under them there's a landscaping subcontractor that's a third-tier sub that's doing the landscaping work. That subcontractor meet these same requirements just like the prime does and then the first-tier sub does. I want to make sure it's crystal clear. If legislative counsel and the author and everyone here is comfortable with that, I'm comfortable with that. I just want to make sure it's crystal clear and there's no wiggle room on that.
With respect to what Representative Bordeaux brought up, as a point of clarification, I would accept it, obviously, as a friendly amendment. On line 27, between the words contract and for, that we include the words with a department, agency, or instrumentality of the state or political subdivision of the state. Include those words in there to clarify that. That would be page 2, line 27, between the words contract and for.
Chairman Knox. I'm sorry, hold on.
It would be between the words contract and for on line 27, and it would say with any department, agency, or instrumentality of the state or a political subdivision of the state.
Mr. Chairman, may I make a suggestion as to where it might fit? And this isn't mine here, this is Travis's. Put it a little bit above that on line 26, where it says contract subject to this article, strike out subject to this article, and say enters into a contract with a department, agency, or instrumentality of the state or political subdivision of this state. I think that's where you want to go.
I agree. Thank you.
And then take out as defined by this article on line 25 and 29.
Take out as defined in this article.
Yes, sir. On line 25, take out as defined by this article because you're really not defining it. And do the same thing on line 29.
It's actually already defined, so you don't need to keep repeating it's defined. It's defined in 131090. It's a defined term for the article.
Yes. And then
you still have the floor.
Thank you, sir. On the line 32, when you're talking about employers, does employers, is that supposed to refer to the department of the state, or the, what is it, the department, agency, instrumentality of the state, political subdivision, contractor or subcontractor, any of those?
The
in other words, City of Savannah has more than 500 employees.
Right.
If City of Savannah enters into a contract with a company with 400 employees, does that come under line 32?
Yes, it would.
All right, because the City of Savannah has more than 500.
Yes.
So I think perhaps rather than saying employers there, your better language would be to say with respect to a department, agency, or instrumentality of the state or a political subdivision of the state, comma, or a contractor or subcontractor.
Right.
Of 500 or more employees. And then repeat the same in B and C on page 3, lines 1 and 2. I hope you remember.
I got it down.
You want this back too?
That's why we're paying her overtime, right?
We couldn't pay her enough for what she does.
I would agree with that. Okay. I know we're not taking amendments yet, but Jill, are you up with us with the language? Okay. All right.
Would you like to move on to Article 4?
Was it Chairman Knox, I think, had his hand up, and then Representative Mangum.
Maybe this is in here and I can't find it, but if you do all these things that you're required to do, and then you find that you have an employee who's not lawfully in the United States through using these protocols the Department of Labor has given us, what then? Is the employer then guilty of having hired somebody under state law that's not entitled to be here? Or if they don't, are they required then under this law to terminate that person after they discover that they're not here lawfully? Or what is it?
The company would enter into a memorandum of understanding to join the basic pilot program. At that time, if they are given information that somebody that they have employed is not lawfully present, they have the opportunity to ask for secondary verification, and they have 8 federal business days to do that. Once they have done that, the time period for the secondary verification to come back is undetermined. I mean, it could come back in 1 day or 1 month. But during that time period, the person is still legally eligible to continue to be employed. If after the secondary verification comes back, it has been determined that employee is not legally eligible to work, then that employer is required by law to terminate that employee. If they don't, of course, federal law governs that. They could be in trouble theoretically.
Okay, so that's under federal law anyhow, that if you discover that you have somebody working for you that's not here lawfully, that you're required to terminate them or do something with them. I don't know what you do after you terminate them. Are they just out on the street, or
I think
you have to call the sheriff, or what?
For a practical matter, you tell them that they're not lawfully eligible to work, and the termination takes care of itself.
Okay, but it's not a criminal offense to be working unlawfully, in the state of Georgia, even if you are here unlawfully. Is that right?
A state offense or a federal offense?
State offense.
Not to my knowledge.
Not any violation. Okay. All right. Well, now I'm trying to understand about the program and what is it you call it again?
Basic pilot program.
Basic pilot program. I understand the company can volunteer to join the program.
Right.
And is our premise that because they volunteer to join this, that they are then in a position to be able to volunteer applicants for that work to subject themselves to this process?
That is correct.
Okay. And so, that being the case, when we do that, aren't we subjecting every person who applies for a job, aren't we putting them in a position by this device of saying that they have to prove that they're a lawful resident of the United States to keep that job? And lawful resident of Georgia, I guess, under this Georgia law.
If they're going to work for the government, or if they're going to work on a taxpayer-supplied contract, then yes, they would have to be lawful.
Okay. And that's only if they're working on one of those kind of contracts?
For this particular code section, yes.
Okay. Are we going to go into that later in the bill?
There's a bill that deals with private employers.
Or is it private employers? Okay. But in any event, in both of those cases, aren't we saying that everybody who, on and after these dates, goes to work for a company that opts into this program has to prove that they haven't broken any laws?
They have to use the system to verify that their newly hired employees are lawfully eligible to work.
Okay, but doesn't that require the employee to show them that he's lawfully here and not breaking any laws? In other words, if I decide I'm going to go to work for whoever tomorrow, I got to come up with some kind of documentation to show that I'm, a citizen of the United States, that I'm legally in Georgia, et cetera, right?
Well, you're going to have to, for your I-9 requirements, which is already required of every employer, you're going to have to do that. But for the basic pilot, you're going to have to simply give them your name. Of course, they'll know the date that you were hired, and you're going to have to give them either your Social Security number or your work authorization number, which will be verified against the database.
Okay, but still, as the employee, right, I'm still having to say that I prove who I am. That's a big difference, isn't it, from what we've had for since the founding of this country, where it was presumed that you were here lawfully unless somebody showed otherwise that you were otherwise.
You're going to have to prove that you're eligible to work, yes, sir.
Okay. But that's based on you being here lawfully and proving that you are someone who is here lawfully, right?
That's correct.
Okay. And would you agree that that's a complete reversal of what has been the case in this country for a couple hundred years now?
No.
Well, prior to this time, if I went to work for an employee,
right,
I didn't have to prove that I was a legal citizen of the United States.
Well, you had to prove that you were lawfully eligible to work, and since 1986 at least, and probably going back before then, in providing the documentation that was required on the I-9 form.
Well, that's another issue, but my point is that prior to the concern over unlawful immigration, one was not required. We don't have a national ID card for that reason. That right, the Constitution says you don't have to prove you're not breaking any laws, and if you're here unlawfully, you're breaking a law, and you don't have to prove that you're not here unlawfully until now, right?
Correct.
Okay, but now we're going to require that, right?
Well, we began, and it may go back beyond 86, but we began requiring that in 86. That you had
okay, well, whenever we started, we still have to do that. Mm-hmm. This law doesn't change that. It's still going to require it's just putting it into another framework where we're going to be able to check on whether or not what we say is correct.
Absolutely.
Okay. Yeah. Now, and I understand the problem with unlawful immigration. I think it's a really big problem. But before we get ourselves committed to this protocol, and I think this comes out of Homeland Security, doesn't it?
It does.
Okay. And before we get ourselves committed to this protocol that the Labor Department is asking us to put in the bill, into this law, and I guess that's where it's coming from, because this wasn't in this before the Labor Department asked you to do it, was it?
No, this portion was. The Article 4 was not.
Okay. But the idea of participating in this program where the company opts in and all that business, whatever that's the pilot program, that's all coming from the Labor Department, right?
No, sir, that's not coming from the Labor Department.
Where's that coming from?
That was coming from me.
The pilot program?
Well, the basic pilot program is offered by the Department of Homeland Security, obviously.
Okay.
And it has been successful. This is the way I conceptualize it. What we've done is we've taken the system now where you hire someone, you fill out their W-2, at some point you send it into the Social Security Administration. They look at it and say, wait a minute, this is a bogus number. 6 to 9 months later, they send it back to you, what's known as a no-match letter. You then go to the employee and say, listen, you gave me a bogus number or a wrong number or something, you got to fix it. They come back either with another number or most likely they don't come back to work at all the next day. That's a 6 to 9 month process, and it kind of rigs the system. What this says is you take that same number, you put it into the system, and 20 seconds later it pops back, is that person legal or not? It takes what is a 9-month process of rigging the system and boils it down to a 20-second process.
Okay. Would you agree that that's a good argument for not allowing the government to use a Social Security number for identification purposes?
That's an issue outside the context of this bill, but certainly I think the Social Security number itself should only be used for tax purposes. But I don't know that we are where we are.
Okay. And I'm not fussing at you about your bill. I like I think we need to be doing something on the state, but I just want to be sure we don't. I don't want to be. What I'm hoping is that we're not responding, and I'm asking you.
Right.
I'm hoping that we're not responding to what the federal government isn't doing, and trying to solve problems that they should be solving.
Mr. Chairman, most likely within the next 2 years, the basic pilot program or something very similar to the basic pilot program will be mandatory for every employer in the United States. That is in both the House and Senate versions of the bill that are being considered. However, this program has been around since 1996 for use by employers in the United States. There was hence the name of a pilot program. It was expanded to all 50 states about a year and a half ago because it had been successful. The President has put $100 million into his budget this next year to expand it even further. So this is without question the way that we are moving federally, but it is also without question the way that these 200 companies right here in Georgia are already doing it because they see the benefits of making sure that they are able to document their work, that their workforce is legal, and in using the basic pilot program, one of the beauties of it is that if a person turns up to be illegal that you are employing, yet the system told you that it was okay, then you're covered. You're not under any legal liability.
I don't argue with the efficacy or the efficiency of the program.
Right.
You know, it's like if we have the technology and you use the technology, it ought to work well. Right. And I can see how it could work very well if you use the technology. But my question is whether or not we ought to be using the technology in the way that we're being asked to use it, because we're not using this technology just on unlawful aliens. We're using it on every citizen who applies for a job in the state of Georgia. And if it goes nationwide, that doesn't convince me that it's right. It just convinced me that nationwide we're using the same technology and maybe making the same error. For instance, recently, we've seen that because we have DNA testing now, somebody commits a murder in some town, the new technique is let's go into the town, ask everybody to give a DNA sample. We'll check their DNA sample and see if any of them compare to the DNA we got off this. And anybody who refuses, they probably are a suspect. Well, everybody that did that, sure, even if they do it on a voluntary basis, you're still asking everybody who's in the town to prove that they aren't the perpetrator in order to get to the guilty person. And that's turning everything upside down in the Constitution in my estimation. I just want to be sure, and I'm asking you whether you think we're doing that or not. I want to be sure we're not doing that in this case.
No, sir, I don't believe so. I think the system we have right now, we've essentially made a mockery of it because we have the I-9 system, which requires us to do what you're already saying. You have to present those documents showing that you're lawful president. And many times over those documents are false documents. This system takes that out. In other words, you're saying, listen, the requirement is you're going to have to prove that you're legally eligible to work. This system takes away the mockery of the system the way it currently is right now. We show up and say, oh yeah, by the way, here's my information, and many times it may be false. So we're getting rid of that. So essentially what this is saying is that here the law is, we got to go down this road. We got to follow these guidelines. This system will help you do it in a lawful, efficient manner and take some of the gaming of the system out of it. So I think that's what we're doing.
Thank you, Mr. Chairman.
I think Representative Mangum, as I remember, had his hand up next. And then Vice Chairman Mumford.
Thank you, Mr. Chairman. One of the questions that I had was going back to page 2, lines 23. We were trying to clarify earlier the type of contract, and you said a public contract.
Correct.
And it also says for physical performance of services. Would you give me kind of for instance of what types of public contracts would be for performance of physical?
Well, if you were building a bridge in the state of Georgia, that would be a physical performance of something in the state of Georgia. If you were processing data in India, that would not be physical performance in the state of Georgia.
So it has to be in the state, not for the state.
It has to be in the state, correct. That is correct.
Follow up, but it would also include janitorial services. It would include painting. It would include technological. It would include any kind of a contract that was for the state, in the state. Excuse me. See, I'm still getting mixed up.
Yeah, in the state for essentially, like a better term, a state agency or a public control.
So that doesn't help at all with the offshoring of Georgia jobs.
No, this bill doesn't seek to address that issue.
So if you're giving a job to an alien, what difference does it make where they are?
If they're in their home country, they wouldn't be an alien.
I mean, for Georgia jobs, public money.
Well, that's another public policy question outside the context of this issue. I mean, if we have decided that we don't want to outsource any of our services, we can certainly debate that issue, but I wouldn't say that is...
Not the same thing?
That's not what this bill is addressing.
Not the same thing? Okay. And why doesn't the I-9 work?
The I-9 is it works to those who want to follow the law, but for those who are going to use false identification, it doesn't.
Are you finding that there are employers that don't use it because they don't want to?
Oh, absolutely.
And does this bill address them?
Well, if they're, this particular section of the bill does, yes, in fact it does.
The employers that don't follow the rules.
Well, they have to follow the rules if they want to do any public work.
Okay. Thank you.
Vice Chairman Mumford.
I really want to try and speed through this because the hour is so late. I think you were here when Representative England spoke this morning. He had some changes on dates that were proposed. I was just looking at the old bill and the new bill, and I wanted to find out if any of those changes of dates have been included or if all the dates have remained as they were.
Well, it's kind of a hybrid.
Okay. I thought it might be from what I was looking at here.
Unfortunately, he had wanted to push back some of the dates, which I would not accept as a friendly one, because we'd already pushed them back numerous times. However, in working with the Commissioner of Labor on this particular section, with the new tier system of when employers of certain sizes are impacted, it's done on different years. I think we've probably addressed some of what he was concerned with in that particular area. So I would say.
Did you talk to him about it, or you're just suggesting that's just your view of it?
That would be my view.
I think that's accurate. Thank you.
And to follow up on that, when I worked with the Commissioner of Labor today and found out the number of employers that were under each of these thresholds, I could safely say that his concern in this area for those particular dates is about 90% addressed, because so many of those employees fall
under 100. Right. Okay. Thank you very much.
Chairman Bordeaux.
Very quickly, following up on my colleague's question about the type of contract. Why isn't this a contract for? Why doesn't this include a contract for, say, a purchase of goods? In other words, if the city is contracting with someone to buy toilet tissue.
Right. Sir, I guess we never considered that.
I don't mean to be so puzzled, but I would think a city or state would have far more contracts for the purchase of goods than the type of contract that's identified here.
I would, and I agree with you. I think at the heart of the matter, when we're looking at somebody working for taxpayer dollars, that we were concerned with people doing public, most people conceptualizing public work contracts, performing those services, as opposed to simply building or purchasing a good from a manufacturer who manufactures sell those goods to obviously far more people than just government.
I'm sorry, that was late. I don't understand your answer, but I appreciate you trying. Maybe talk more slowly and use smaller words at this hour, but thank you.
I am from the north part of South County, so
we all have our burdens.
Representative Setzler.
I think real quickly to Chairman Bordeaux's question, I think the issue of vendors, I mean, so many vendors have multi-state holdings. I mean, when you look at, just look at tax law, you see how folks have assets spread all across multiple states. I mean, I wouldn't want to think that we couldn't buy toilet paper from a company that has holdings in multiple states in areas outside of Georgia. I mean, service providers typically are within the state. The performance of contracts and service providers, folks have it just seems to me have or organized corporately in a way that it's relevant to have them do this for Georgia employees. Vice, someone that would provide toilet tissue, provide water or paper or whatever. It seems a lot less clean when you start talking about vendors for products as opposed to services. It's much less wieldy and doesn't.
Coca-Cola used to be a Georgia company, I think. I'm just wondering.
No, I understand. Right. If you understand the basis of this, I think there's when you delve into it, I think it's a much messier thing for vendors than it would be for service providers.
Okay, next would be Mr. Bordeaux, I guess, again. We're done. All right, is there anybody else? Are we done with this section then, I hope? Thank you. You want to move on to the next section?
Yeah, Article 4, which you find on page 3, is what the Department of Labor brought to us today. Responding to the Commission's concerns that the basic pilot program only dealt with new hires. His concern that we may actually, by setting up a date, and realizing we're only dealing with new hires, that we've actually creating somewhat of an amnesty. I would suggest because lack of enforcement, we may already have that. But he wants the authority to begin using his department to check businesses for not only new hires but for all their employees. And you will find that authority in the creation of what's known as the Georgia Immigrant Work Verification System in Article 4. His attorneys, I think, are still here. We need questions answered specifically on this particular portion of the bill. But essentially what the Commissioner would like to do is take those same systems, the basic pilot program, the Social Security Administration, or other federal agencies, one in particular being the SAFE program, and use all of that information to begin checking, randomly checking employers throughout the state. His section, I will tell you, is subject to funding, and that's something he was concerned with. But that we set the same thresholds in this section. You'll notice on page 4, lines 4 through 6, as well. We may need to amend that lines 4 through 6 in the same manner as we amended the previous section. Now, with respect to the word employers.
Perhaps the easiest way to do that is just at the beginning of each article, or I guess each article is to come up where we're just create a definitions code section, and where we define state work authorization program, we also define public employer and contractor, and that way we can just use it as a term of art, defined term.
I agree.
Thank you. But you just did 1310.110. Let me. Yeah. The line 23 on page 3, you talk about it's the Commissioner of Labor shall commence enforcement no later than July 1, 2007. Why do you have that in there?
Well, we could ask the Commissioner's people here, because they want to draft it. I can only assume what we've done with much of this bill is allow those dates to be set sometime in the future to allow the governmental agencies to have to effectively assist, in this case, the Commission of Labor, to get the rules and regulations in place, and, I think more importantly, to be notifying employers that this is coming and we need to get prepared.
Under 1310.111 on line 25, it doesn't become effective till July 1, 2007.
Correct.
So isn't your language about it, they couldn't enforce it any sooner than that date, so isn't the language on 23 superfluous and confusing? I don't think we'd lose anything by losing the language.
It may be superfluous, I'm not sure if it's confusing, but I'd be happy to get rid of it.
Well, in other words, they couldn't start enforcing it
right.
June 1 as opposed to July 1.
Correct. I think the reason that he included that language when he referred to the word no later is the Commissioner's belief that by setting a certain date, you almost entice employers to violate the law at a much greater rate, I suppose, up until that point. In other words, if it's an employer's mind, I need to hire some illegals, I got to do it before this date. And I think the reason he put no later is would be to kind of leave the door open that, well, he may start enforcing that sometime prior to that point.
Could they enforce it prior to that point?
Well, not in reading line 25.
Okay, so.
Yeah. So I think we'd like to remove that. enacted in November 2006 on line 22.
What page?
Page 3.
Page 3 is going to be line 22 for the period after 2006. And the rest of that sentence enforcement related to 2007.
And does that include striking 13, 10, 1, 11 parts of it?
No.
Chairman, could there be problems so that we don't cover our bases on this, maybe adopt these
Amendments as we go.
provisionally?
I'm beginning to think that that's a good idea myself. I know Jill's really good at keeping up with us usually. Well, let me just ask it this way. As to this particular change, I took that to be pretty much a friendly amendment and was accepted by the author. Is that correct?
All the amendments that we have spoken of so far, I would consider friendly.
Well, let's take this one itself. Is there any objection from the committee to this amendment right before us, the one at page 3, line 22? Hearing none, we'll consider that amendment adopted. Now, I guess we better go back and at least reference, if we can, the others.
I suggest that just whether we say it's adopted, we adopt it effect provisionally because it's followed the right order. But go ahead and mark it up as though we've adopted it, and then come back with a motion to accept all the amendments. But we adopt it provisionally.
All right. So we'll call that a provisional adoption, I suppose. That's what my family did to me.
Should we go over the other amendments?
I would like to, just so we're all very clear. That would be great, Jill. And then if you have any objection to any of these, you holler.
What I was supposed to do in page 2, line 11, 13, 10, 9, would begin by saying, as used in these articles, the term, number 1, contractor means a contractor or subcontractor who enters into a contract with a public employer. Number 2, federal work authorization program means, as is written out there on lines 12 through 17. Number 3, public employer means the department, agency, or instrumentality of the state or political subdivision of the state. Then beginning on line 19 to say,
all right, well, let's take that section right there. Any objection to that? All right, is there any objection from any member of the committee that is provisionally adopted? Go to 131090.
On or after July 1, 2007, every public employer shall register and participate in the federal work authorization program to verify information of all new employees. Period. B1. No public employer shall enter into a contract for physical performance of services within the state unless the contractor registers and participates in the federal work authorization program to verify all employees. And number 2, no contractor shall enter into a contract in No contractor shall enter into a contract or subcontract in connection with the physical performance of services within the state unless the contractor registers and participates in the federal work authorization program to verify information of all new employees. And that gets a little confusing because within the definition of contract, it's either the contractor or the subcontractor. That's why that language is a little dicey. And then number 3, paragraphs 1 and 2 of this subsection shall apply as follows. On or after July 1, 2007, with respect to public employers or contractors of 500 or more employees. Page 3, replace the word employer with public employer or contractor on both lines 1 and 2.
All right, so that concludes the amendments in section 13-10, 91.
Mr. Chairman, what was your question? What was her question about the language being dicey?
I'm just trying to, because I'm doing it in my head as I'm reading. And contractor is the defined term now and includes contractor or subcontractor. So I was trying to make sure I was reading it correctly. Page 2, lines 26 through 30, and capturing your idea.
All right, is there any there's no objection from the author. It's a friendly amendment. Any objection from the committee is provisionally adopted. As to Article 4, isn't it just the dropping of the last sentence, essentially putting a period at 2006?
Yeah. We would also want to do the same thing with respect to defining public employer and contractor, I believe.
Okay.
And then
Where is that?
Representative Bordeaux mentioned there's an issue in the beginning. We start, and I don't know the name of this department, and perhaps the author can share this with me. The Department of Homeland Security is the official name of it.
She's going to read that.
Department of Homeland Security of the United States, or it's the United States Homeland Department of Security, but because interchangeably in a couple pages here we use Federal Department of Homeland Security, Department of Homeland Security of the United States, and the United States Department of Homeland Security, and probably being consistent with each
I
other.
think for consistency matters would be, the appropriate term is the United States Department of Homeland Security.
Question?
That change would be made on page 399, and then wherever else it applies.
Yes, Mr. Sessions.
Does the definition of contractor include contract employee? I know, for example, under federal contracting, we work. My firm works on a number of federal contracts, and we hire employees. They're treated very differently in terms of their contract status than would an employee that's hired as a contract employee through a staffing agency or as an independent contract employee. They have different legal status, they have a different insurance status, and I want to make sure that contractor or subcontractor would include a contract employee. Because again, you could end up having illegals set up as contract employees who aren't employees of a contractor or subcontractor that could skirt this. I want to make sure we can catch that. And I don't know if we need to include that in the definition of contractor, but whether it's an employee through a staffing agency or an independent contract employee, that has to be addressed, I believe.
So the way I believe it's used here, and the way I tried to incorporate it in the definition, let me just read it to you again. Contractor means a contractor or subcontractor who enters into a contract with a public employer. I think that's what the language from the bill. And public employer is defined as a contractor who enters into a contract with a state agency.
Okay. I'm not coming up with hypotheticals. I mean specifics. Hurricane in Florida. There are a number of large contracts for re-roofing, and you had contractors that would go out and they would get 50 or 60 million square feet of roofing space. You're talking 5,000 homes, and they'd say, "We got it," and they would go out and get subcontractors working for them, who would have third-tier subcontractors, who in many cases would get contract employees, not on the payroll of their company, but were contract employees that weren't being signed on to their payroll, that they were not reportable as employees, but would still need to be covered under the provisions of this. Or there's a very easy way to sidestep this, and I know that's not your intention. I believe
the definition, as the council presented, that person, that contract employee, would be entering into a contract, and they would be performing the services of that contract. The latter word, so to speak.
Okay, I really want to return to our task if we can, because we do need to finish this sometime before midnight tonight.
But again, Chairman Mumford, I want to make sure we don't have a hole big enough for a truck to drive through. And
I understand that, but
I'm confident it's closed.
All right. Now, we were on 1310-110, and I am not sure what the amendment was on 13. Mr. Jacob, did you have something?
Not the amendment.
Yes.
I think we missed one on page 2. Actually, missed 2 on 2. On line 25, as defined in this article, and same thing on line 29. I don't know that we provisionally adopted those.
I had that struck through.
Did you? Okay. All right. Thank you. I apologize.
I think it's struck through in both ways.
we got
Pages 21, 25, and 29.
And then on page 3, line 30 and 31, the same thing, and 27.
Are we waiting on the chairman?
Representative Jacobs.
Thank you, Mr. Chairman. Just a question for Senator Rogers, and maybe someone from the Commissioner's office can, might need to chime in here. But as you'll recall, in the subcommittee hearing, I had expressed some concern about the program that the Commissioner was proposing. And I understand you met with the Commissioner and arrived at a compromise, but now I have some concern about that compromise. I had some concern about the program that the Commissioner was proposing vis-a-vis the existing federal program, and that the program that the Commissioner was proposing involved higher state overhead, whereas there was already an existing federal pilot program that the Commissioner would be responsible for promulgating rules to carry out here in the state. What it appears we've ended up with now is both the federal program and the state program, and I wonder if that causes the author any heartburn. I mean, it certainly concerns me that we may be ultimately creating duplicative programs, and not in the most streamlined way, and not in the most efficient way for taxpayers.
I appreciate your concerns. The federal program, of course, which is appropriately pointed out, is much less costly because it's free, addresses people that are newly hired, and it is mandatory for all of those persons that are public employees or working on public contracts. So all those persons would be verified through that system. The Commissioner's program would allow him to do, for lack of a better term, spot checks or audits. I think would be more appropriate. Audits of specific employers that he would choose throughout the state. There would not be any mandatory requirement for every employer working on public contracts or a public employer. He would simply do audits as he sees fit to make sure that those particular companies have legal labor, and it would not specifically deal with people that are newly hired, but it could be anyone in their employment. So I think it does address two areas. It gives him a tool in the normal tools of using audits to begin enforcing this particular law. Could it be? I mean, there are areas where we might be duplicating the process, but I think in general, we will. If our goal is to create a legal workforce, this will certainly benefit.
But in the original provision that was in the committee substitute that we reviewed during subcommittee, and in this version with respect to the federal program, there is a provision that allows for the promulgation of rules by the Commissioner of Labor. I mean, could he not also achieve the spot checking objective using the federal program through his rulemaking authority?
Well, you wouldn't really have it in the federal program. You wouldn't really need a spot checking program because it captures everybody. There would be no reason to have any spot checks. His program allows him to audit a business and verify not only those persons that are newly hired, but everybody that's employed there. In reality, 10 years from now, would his program be necessary? Probably not. But as of today, there would certainly be some value in verifying not only people that are hired after these particular dates, but anybody that's on the payroll. I think that's the tool he's looking for.
All right, further questions? Does that take us to 131011 or 1310 111 or 1310 110? Is everyone content with our work on 1310 110? 1310.111.
We've taken out as defined in this article on the third. Please.
Yeah.
New section.
We're going to approve them.
Representative Setzler.
I will have one subsequent amendment to make if you want to keep moving on. I can offer some now for later. I spoke to some other members of the committee that I do want to address concern. I can offer it now or I can offer it later. Pleasure, Chair.
Did you take up any amendments?
Well, what we had done is we had provisionally approved these amendments that she has been reading, and I guess the last thing to say is on this last section, you don't have an objection to those amendments. They're essentially housekeeping amendments. Does any member of the committee have an exception? If they don't, then they're provisionally accepted. We were going to come back and have a motion at the end, so that's where we are. We're through with this section, and Jill supposedly has the language down as to what it's supposed to be.
Let's go ahead and take your amendment up.
Mr. Chairman, I want to, again, since I have to track her language perfectly in writing, my language would say words to the effect of contractor, any tier subcontractor, staffing agency or entity, or contract employee. And I don't know that we have time to go into it. My profession is doing federal contracting for a large engineering construction firm. If that stuff's not there, it wouldn't hold water in the federal contract. And I think we ought to, while we're doing it, address it. I'm just concerned subcontracting broad enough that a staffing agency providing services to a subcontractor who hadn't vetted their employees could provide employees to a subcontractor. Not employees of the subcontractor. There's no requirement for them to vet the employees that are being provided by a staffing agency. That staffing agency hadn't been required to subsequently provide that screening they could be providing illegal workers.
Chairman Bordeaux.
The employees doesn't cover basically a temporary worker, if you will, or a contract, somebody who they just bring in on a contract basis.
A temporary worker is not an employee. Right. A temporary worker is provided on a contract basis, and.
But your problem is not with the definition of a contractor or a subcontractor; it's with who's an employee.
it's with. Well, I think we all understand they're not employees if they're a contract employee. My concern is more in the definition of subcontractor. It could be construed that a contract employee working for some entity in this contractor or subcontractor, you could construe a contract employee as a subcontractor of that entity. Or you could make the case, they're not really subcontractors, they're just contract employees, or they're provided by a staffing agency. And you could make a case that the staffing agency is serving as a subcontractor and their service is providing employees, but I think it's really murky when you do that. Do you understand what I'm saying?
No, sir, no, I'm sorry.
Okay. What I'm saying is, as it's drafted, a contractor would have to vet their employees and ensure that they're legal. Okay. If, as part of their staffing plan, they utilized a staffing agency to fill out their requirements, the staffing agency would actually hire and employ these workers. They'd provide them insurance, provide them benefits, and put them on the contractor's work site. And rather than being an employee, the contractor would pay the staffing agency for professional services rendered. Unless that staffing agency has to be vetted, they could provide illegal workers to the contractor, and the contractor's clean.
Right. I do understand that, but I think the way to address that is to define what's an employee and what's not.
Well, there's one other combination that could be similar. An employee could come to the contractor, not the staffing agency, and not through an application for employment, but could represent themselves. I'm a contract employee. You can 1099 me. You don't have to worry. You don't have to put me on your payroll. You don't have to pay me. You don't have to cover my insurance. You don't have to cover a whole number of things. I'm a contract employee of yours, and they could be construed as a subcontractor. But I want to make sure that, for purposes of this, it's very clear that both of those circumstances could apply, because I know specific contracts, multi-million-dollar contracts the federal government's led over the last year, where thousands of such employees have been employed for performance of services. So I think it's very relevant here.
Would it be all right if we said subcontractor means the definition, or will I use your definition fully?
Well, again, the thing that I think is clearest, that I don't think makes the bill murky at all, is contractor, any tier subcontractor, TIER, staffing agency or entity. These are the folks that have to.
Are you defining a term? Give this description.
I'm defining the subset of folks who have to, that are included under 13.10.111, and are further included under 13.10.91.
Mr. Chairman, I think I agree with what Representative Seth is saying. I also agree with what the legislative council is saying. If we took what he's asking and defined that as a subcontractor, that would cover it correctly.
Yeah.
Are you accepting his amendment, subject to the will of the committee?
Yes, sir, I am.
And I think it'd be cleaner if it were there, because it could apply throughout the whole.
Yeah, if we define subcontractor with the language he was just referencing. I think that's the cleanest way to do it.
So it would be any tier subcontractor, staffing agency or entity, or contract employee. I would be thrilled.
I think wouldn't any tier subcontractor already be subcontractor?
I think we ought to specify that.
Subcontractor means any tier contractor, staffing agency or entity, or contract employee.
But any subcontract regardless of its tier.
It would be any tier subcontract.
Well, I mean, I would just say, I understand what Representative Setzler is getting at, but when you look at when you look at language such as this and you see a term, tier subcontractor, it's quite possible that someone's going to be looking for guidance as to what a tier subcontractor is. It might be clear to you right now, and it's clear to me what you're saying, but it may not be clear ultimately when someone is construing the language, looking at the words on paper in the code. Representative Bordeaux's language is a little bit better in that regard.
I'm fine with the language, but I do think it needs to be specified.
Joe, would you like to clarify that for?
Any contractor, regardless of its tier, in other words, whether it says tier, any tier contractor, any contractor regardless of its tier.
Got it? Okay. Yeah, and I've got another idea, and I have another idea working, but move on.
Section 3. This deals with the section on human trafficking. Like this, they've been waiting for patients like we're going to prosecute the council to help draft this. Maybe it would be beneficial to exercise the prosecution. No.
Is there any real discussion on this section?
Why don't you give us a concise explanation, and then if it's the committee's desire to hear further.
That's good.
I haven't heard a lot of controversy about that part of the bill.
We have defined labor servitude and sexual servitude. And also sexual servitude and labor servitude for persons that are minors. And if you look at page 6, beginning of line 7, the person commits the offense of trafficking with a person for labor servitude. And then give definition there. Line 11 is the same thing for sexual servitude. Line 15 starts the penalty phase. 1 to 20 years for labor of sexual servitude. And beginning on line 17, any person who commits the offense of trafficking with a person for labor of sexual servitude or a minor, not less than 10 years, not more than 20 years. That is the main portion there. I'm going to have an amendment to section 4. We don't have a question on section 3.
Jill, did you have a comment on section 3? Okay. Okay. Now, and you have had a resource person, Cobb County?
Yes, sir.
And do you have anything to add or any comment about those changes? Yeah. Okay. Okay. Thank you. Chairman Bordeaux?
Taking out district attorney and prosecutor, wouldn't the attorney general then be a quote a prosecuting attorney?
No, when we use attorney general in the code, we actually do use it specifically and we define it. Prosecuting attorneys just incorporate both state court and
solicitor
court. That's generally where it is. Although you are correct, obviously, the attorney general does prosecute and would be technically prosecuting attorney by distinguishing that.
Thank you very much. Thank you.
Now, we're on section 3. Now, one final call for questions or comments on section 3. Let's move on then to section 4 on page 7.
Chairman, I want to make this really easy. I have an amendment to strike section 4.
Second. That also strikes the language in the preamble that Jill knows about.
And you'll handle that, Jill? Okay. Any question about section 4, which the author has requested be deleted? Section.
It says reserved. I think is what the amendment says.
Should we do that or renumber, Jill?
It's going to depend on where, we have to look at the subsection to see if this section is something that should, in the middle, it needs to be reserved, or if it's at the very bottom, and we don't reserve last numbers. So this is not finding where
Okay. Section 5.
Section 5 relates to what happens when a person is put into jail on a felony charge or a DUI charge, as it pertains again to using one of the tools that is offered to us by the federal government. That is a very successful tool under the Law Enforcement Support Center. Essentially what this section does, it says when a person is put into the jail on that felony or DUI charge, that the jail authority would attempt to determine the nationality of that person is confined. We are already actually required to do that by treaty that was signed back in 1967. If that person is in fact a foreign national, then the jailer would go on to attempt to determine whether that person is lawfully present. If they cannot determine whether that person is lawfully present, they will make a query to the Law Enforcement Support Center, which is part of the United States Department of Homeland Security, to use the inlet system, which I think Representative Beard can confirm to me is available to every law enforcement officer and in most of the vehicles. It's the same system that's used on pads. And the Law Enforcement Support Center will determine whether that person is wanted elsewhere for a felony or whether that person has a standing deportation order against them. At that time, Law Enforcement Support Center, as a trained Immigration and Customs Enforcement agents, it's manned 24 hours a day, 365 days a year. They would put a hold on that prisoner for federal authorities to pick up that prisoner after he has been processed for whatever state charges.
Let me, before you, Jill. Okay. Any objection to that? Okay. Vice Chairman Mumford.
Trying to be very brief here. I heard in our this morning when we had some witnesses, there seemed to be a lot of, the idea was that somehow or another this provision was going to cause a large number of people to be held in jail. Was that the intent of the provision?
No, it wouldn't serve. First of all, these people would have to be charged with felony or driving an influence. I would assume they're going to be in jail for quite some time anyway. But I think more importantly, according to ICE regulations, they have a maximum of 48 hours to pick up that person.
Well, what I was getting at is, would there be any objection to adding in on page 7, line 19, after the word confined, the words for any period, and then adding another section C down at the bottom and renumbering the current C to D, which would say that nothing in this code section shall be construed to deny bond or release from incarceration to persons otherwise eligible for release. In other words, if they don't get a hit, if they don't have some reason to continue to hold these people, that they wouldn't be just held for 48 hours or for any period until they got the information required back. I would offer that as a friendly amendment.
As long as it makes sense.
I can give you that language.
Senator Rogers.
As long as it makes a friendly amendment. There was one I was alerted to before. After this was printed, I didn't want to go through the printing process again, but if we could strike on line 31 the comma after association, all the way through the comma after public safety. So it would read the Georgia Sheriff's Association shall prepare and issue guidelines on the rest of this paragraph. That would be correct. That would be appreciated.
Okay. Questions or comments on Section 5? Chairman Bordeaux.
Jill, for this. Well, let me ask you this while I'm waiting on Jill to come be available. Is it your intent that this check is supposed to be run just basically once initially when the person is arrested? And, right, not when they're, for example, if they're transferred from one jail to the next. It's not supposed to take place each time.
It's not, and I would hope that would be addressed in the guidelines and procedures set up by the Sheriff's Association. But it is my intent that obviously they only once they're originally booked in jail, that they will be verified.
Because I don't think that's clear from this language, because it just says anytime you're confined in a jail, in a municipal jail, regional jail, and that to me would mean that each time a prisoner is transferred from one of these jails to another check is supposed to be run. Is that how you would read it? And if I may ask legislative counsel, what's the right way to do this on line 19, page 7, when it's talking about DUI? Is it supposed to be? Are we supposed to make reference to a particular code section? Driving under the influence pursuant to 46.391. Is that the better way to do it, or does it matter? If it doesn't matter, just don't be shocked.
I was just curious.
A lot of times we do reference it because of the need for specific. I think it's probably better draft.
Okay, thank you. Then would the gentleman take that as a friendly amendment, since we're doing so many of those? So on line 19, after driving under the influence, pursuant to code section 40-6-391. Just 1 second. And I don't want to think out loud, but in terms of clarifying what that means is, would it be when a person is initially charged with a felony or DUI pursuant to that code section, the jail, please.
If you did something, we could begin the code section on line 19 and say, except as provided in subsection C. And say number 1 and C would be if they're Mr. Mumford's amendment, if they're other than entitled. And number 2, if they're being transferred from one jail or
Subsection shall not apply.
Right,
transfer.
For transfer from one jail to another jail.
That's where Gibson then takes back.
I don't know that it would be a bad idea to run them every time you put them in, because some places aren't going to run them. I can assure you of that.
But is that?
Representative Mumford on that, I think would leave the way it is to several places.
I don't want to put the jailers to.
The DA from Cobb smiled when I said that.
Well, there's usually not that many transfers that go on as a practical matter.
So you think it's okay as it is?
I tend to agree with Mr. Mumford.
Okay.
There will be some places that are probably not going to do as good a job as other places.
All right. Thank you.
All right, what's the next section? Is the next one the notario section? I don't think there's any objection to the notario section. Is anybody, section 6, has anybody got any comments or concerns? This has been widely embraced, I think, by the Hispanic community. It was brought by Mr. Zamarripa. Any questions about this? Do we need to go into section 6 in any further detail? And hearing none, we're moving on now. Section 7. I guess you better tell us about
Section 7 is the section that deals. Section 7 deals with compensation to individuals and whether or not that compensation is a deductible business expense. If you look in lines 26 through 29, we define the term identification and employment authorization document, and it means any of the unexpired documents that are already included on the I-9 form. The I-9 form, of course, as you know, is the form that every employer is required to verify a number of documents off that list. You move over to page 12. The meat of the section begins on line 7. On or after January 1st, 2008, no payment of compensation for physical performance of services in the state of an individual $600 and more per annum. And lists, whether it's wages, salary payments, labor benefits, any kind of exchange expenses, may be claimed as a deductible business expense for state income tax purposes unless a person was given one of the documents, one of the identification and employment authorization documents. We also clarified that this is not what we're going to do for issuing a 1099, which is really what's happening in the marketplace.
Tell me what that does, please. I'm sorry, my brain's fried. What
Essentially, if you were going to compensate someone, whether they work for you or whether you are given through paying them as contract or subcontract labor, granted through the 1099 at the end of the year, they would have to provide you with one of the documents that's on the I-9 list. And if you did not receive that document, you would not be able to declare that as a business expense.
Thank you.
Well, there's an amendment. On page 12, striking lines 25 through 27, essentially getting rid of paragraph F. That was trying to alleviate the concerns of friends of Aflac and ended up figuring out that we didn't really so that's all.
Okay, great. Is there any objection to that amendment proposed by the author? I'll second it myself. Since all the objectors seem to have gone out for a water break, I guess we're ready to move on then.
And section 8, we're almost done.
Those permissions are out to go to straight federal
Yes.
department.
Yes.
Bring that up again.
Section 8 gets us to the section dealing with public benefits. And we'll find again on page 13, start at the top there, shall verify the lawful presence of any natural person aged 18 years of age or older who has applied for state or local public benefits. Now, in your packet, I'm not going to go through this, but you will find the definition of state and local public benefits as defined by federal law. You will also find the most important section of federal law as it pertains to what we're doing here today, and I think it makes it crystal clear that we're not only within our bounds, but we should be doing this, and that's Title 8, Chapter 14, Section 1625. It says a state or political subdivision of a state is authorized to require an applicant for state or local public benefits as defined in Section 1621 to provide proof of eligibility. So that's what this Section 8 as well seeks to do, is provide proof of eligibility. If you, beginning on line 7, we have all of the requirements, all of the things for which verification of lawful presence is not required. Pretty much this is straight out of federal code, where these items are not required. If you move down to line 32, it says verification of lawful presence shall occur as follows. A person will come in and they will sign one of two affidavits, and this is where the gentleman who spoke earlier was a little confused. They don't bring in a signed affidavit, they sign it at the spot, and it doesn't require it to be notarized to say an affidavit. But it will be explained to them that signing a false affidavit is a felony. Of course, a felony conviction is grounds for being reported. So there's clearly a reason there not to sign a false affidavit besides just the felony penalty stuff here in the United States. So the person would come in, they would sign one of two statements. They could either sign a statement, an affidavit saying that they are, in fact, a U.S. citizen or a legal permanent resident age 18 or older, or they would sign the second affidavit saying they are a qualified alien or non-immigrant under the federal INA Act, 18 years old. For those persons who have signed the affidavit stating that they are a qualified alien, we would verify their information through the SAVE program. SAVE program is offered to us by the federal government. This is the one actually that Commissioner Labor spoke of earlier. This state already uses the SAVE program for much of what we do, verifying benefits. So we will continue to use that for all of these persons. And
you made the change to United States Attorney General that we talked about in the sub. I saw that.
And that's pretty much what that section does.
Questions on Section 8?
We clarified with some clarification language dealing with where the term or political subdivision of the state should fall. So we haven't had to just simply clarify that.
Where does that go?
On page 12, line 34, on page 13, line 4, and on page 14, line 18. The way it would read, Mr. Chairman, for example, where it currently reads, an agency of the state or a political subdivision thereof, it would read the state instead, an agency of the state or a, or a political subdivision of the state.
Further
Read that
questions?
again.
Instead of a,
Yeah, I'm with you now.
instead of a state or political subdivision thereof, it just says a political subdivision of the state.
Okay.
And where that is found in 3 places, it's clarified.
And you're asking for that amendment?
Yes, sir.
Okay.
Mr. Chair?
Representative Setzler.
I just want to confirm that political subdivision includes any school district, city, county, authority, any such.
Okay. Any problem, I know we're not voting, but is there any problem or objection to that amendment requested by the author? Okay. Anything else on section 8? Any further questions or discussion? Jill?
Every time this phrase agency agency blank political subdivision of the state, is it always supposed to be or is there one occasion where it says and correct?
What line is that?
If you look at the amendment and 3711, you see that it says or in one location, but it says and on line 5.
Which?
And everywhere in this section of the bill, section 8, is it always supposed to be?
It should be or.
It should be or. That's what I was thinking.
You're correct.
Further questions or comments on section 8? Section 9.
Section 9 simply sets the effective dates for the bill and references the addition made by Commissioner Blair that it would be subject to the appropriated funds in that particular section. That's all section 9 does.
Questions or comments? Section 10.
That's it.
Okay. What did we decide to do about, did we reserve that section that we deleted?
I'm sorry, I didn't look it up, but the restricted term this year indicates the last one, so we would be just.
Okay. All right.
But I'll check that.
Okay, but I got an announcement to make here in a moment, but any questions or comments on the bill as a general matter? Okay. How many, Jill, approximately, how many friendly amendments did we do? Provisional / friendly amendments. Okay. Well, there may be others. I don't know, and I don't want to preclude the committee from moving on those. Can you give us a rough number?
20.
Okay. Here's what I'm thinking of doing, and I'm open to comments from the committee. For purposes of scheduling, it matters not whether we vote this out tonight, now, or tomorrow. This committee takes a lot of pride in its work, and my sense is that this committee would like an opportunity to review a new version with the friendly amendments prior to voting, which will also require you being at your computer for quite some time, I would imagine. Correct? So what I'm inclined to do, Senator, is ask Jill to put that together for us, get it to us as soon as reasonably possible in the morning, let us look at it, and then put it back down tomorrow for voting. I'm not sure if we have any contested amendments at this point in time, but I mean the committee's certainly free to make those and then vote the bill up or down tomorrow.
Chairman, I appreciate that indulgence.
We've had a lot of hours.
I defer to your wisdom.
I know your desire was to move it as quickly as possible. We've had a good discussion, though.
Correct.
And so do we. Do I hear any objection to that idea?
Did we fix the...
Because as of right now, the only bill on tomorrow's agenda is Senate Bill 603. The Mumford Subcommittee is meeting in the morning, and I may or may not take those bills up because we're going to give priority to Senate Bill 529. And if you want to make notes, I'm making 2 or 3 more subcommittee assignments. This will be the last subcommittee assignments for this session. Senate Bill 123 to Chairman Knox's subcommittee. Senate Bill 408 to Knox. Senate Bill 522 to Knox. Senate Bill 541 to Knox. Senate Bill 425 to Mumford. And having made those, and I know y'all are busy, just use your best efforts at trying to schedule something, and I know you will. Representative Setzler.
If the committee were to act today and give a do-pass recommendation, or vote a do-pass recommendation, and there were a desire to reconsider based on some clerical irregularity, would the committee be able to do that?
Well, it's the chair's preference to not get into correcting clerical errors, not that we would have any. And so that was a large part of why I wanted everybody to have the benefit of looking at the final product, which has been modified, although in friendly respects has been extensively amended here tonight. And so I thought for purposes of a good, thorough review of the bill, and given the hour, it might be a better product to do it the way I suggested. I guess the alternative would be to go back through and vote all of these, and then if we get them wrong, come back and change them. Is that what you're suggesting? I mean, is that your suggestion?
I'm just asking. That would be the requirement.
I think we're going to stay with Plan A. All right, any questions about agenda, scheduling, subcommittee assignments, meetings? Mumford's meeting in the morning.
At 9:30 here, we have 2 bills regarding telecommunications. It should be very brief.
Upon adjournment. 2 o'clock or upon adjournment. Thank you all. Meeting's adjourned.